April 2025.
So what is the urgency?
Urgency is there.
No, sorry.
Without all
You
the
file it properly.
May I be allowed to mention one matter, Your Lordship, to take this matter urgent on an urgent basis, Your Lordship. Since Your Lordship, the petitioner is the Your Lordship candidate appear in the Your Lordship the recruitment process undertaken by the PSC. He was selected initially. Thereafter, Your Lordship, he was debarred on the ground, Your Lordship, that the OBC certificate in which he got benefit, Your Lordship.
Not arguing a case.
Yes, Your Lordship. But Your Lordship, the
What is the urgency? What has happened?
recruitment process is
The
about to
tribunal has
conclude, Your Lordship.
rejected your OA.
Yes, Your Lordship.
So
On the
it
last
will be
occasion, the matter
considered.
was taken up, Your Lordship.
Yes.
Learned Counsel, Your Senior Counsel, Tapun Kumar Mukherjee was
Many
there.
matters were taken up, sir. They cannot all be taken up in the last week. You have to wait now. Sorry. Yes.
Regarding item number 140 and 140 of
No, sir. Yes.
40 of your lordship's list dated 17 September, earlier on the last occasion matter appeared. These issue involved in this for regularization of temporary polytechnic college professors. My lord,
We'll see after the
Justice
audit.
Vikramnath's judgment, my lord, saying my
We'll
lord,
see now after the audit. Cannot be. We are sorry.
It has to, just to clarify the situation.
They will do it. Don't worry.
Please wait.
May I kindly renew my prayer for mentioning that two matters were heard by your lordships and judgment was delivered, that I have preferred a clarification application regarding the refund of the overdrawal amount. In the judgment, your lordships was pleased to hold that recovery is not permissible. Now, my lord, if that is correct, then the refund I am entitled to. Now, my lord, while the judgment was delivered, my lord, regarding the point of refund, my lord, there has been either no negation, neither it has been allowed. My lord, I have given the slip, my lord, let it appear tomorrow, my lord, only for the clarification that whether I am entitled to refund or not. Only on that point, my lord, to be mentioned as tomorrow, my lord. I prefer.
The tribunal, what did the tribunal do?
In the tribunal simply stated that recovery is not permissible.
So you did not challenge that order?
Yes, I have challenged that order only. And I have also sought for the refund of the
You have challenged the tribunal's order, or
yes.
the respondents have challenged
No, my lord, this is the overdrawal issue. My lord, I was agreed by the part of it, where only the.
So both sides had filed?
Both sides had filed, my lord.
Next week it will come.
On Monday, my lord, as to be mentioned?
We'll see, yes. Let it come under the heading to be mentioned on Monday. You inform the other side.
I have. See,
that
Mr. S.C. Prasad is there.
appearing.
Yes, but I have already served also the copy of the can.
Tell him Monday we'll list it. Call the list.
May I hand over this list so that the matter will be listed?
Call the list.
Item number 1. My lord, may I be permitted to mention one matter?
Yes, sir.
My lord, this matter is appearing in the adjournment motion, my lord.
Yes.
And the urgency is, my lord, petitioner service matter is due to submission of the review CR in the service record, for which the petitioner is going irrevocable loss, my lord. If the matter,
what are you saying?
My lord, if this matter will be not heard, my lord,
yes,
then the very purpose of the writ petition will become infructuous, my lord.
Yes. What
the
is
last
the very
date was,
purpose?
my lord?
What is the very purpose?
My lord, for a review CR, my lord.
Huh?
For review CR, my lord. The last.
What will become infructuous?
What will my lord? The last date was given, my lord, 4th of this month, my lord. After that, the matter was not heard, my lord. So the very purpose of the writ.
There is a direction for listing on 4th.
Yes, my lord.
It must be on the list. You check.
My lord, it not appropriate heading, my lord.
Is it on the list? It is not on the list.
No, my lord. The direction was given on the matter should be.
Sir, you have said there is a direction for listing on 4th of September.
4th September, not my lord. And on appropriate heading, my lord.
Direction. When?
My lord, date was not given, my lord.
How it can be? No date is given. Where is the order? Show us the order. No, not this. He's mentioning something. He's mentioning it is not this matter. Where is the order? Come with the order. Come tomorrow. Yes, call the list.
Much obliged.
Yes.
Lordship, I am on behalf of the petitioner.
My lord.
Yes.
My lord, may I, my lord, I am suffering from, my lord, I am for the petitioner, my lord, I am suffering from, my lord, fever, high fever. Let my junior move it, my lord.
But before taking up the matter was appearing as 253 in the list.
Was appearing as?
253 of the list.
Yes.
235 were. No notice has been given to me. Just today in the morning, I seen the item number 1.
It didn't come last night.
Last night,
So what is it? You must have seen what is there. What is the issue? Tell us.
regarding the appointment and compression count and retirement benefit.
Yes.
Two marriages there. And my land fund is appearing for the response number 6.
So just a minute, we'll take it. Don't worry. We are just trying to understand what the issue is. He was mentioning that something is that some child is ill.
Yes, my lord.
And if it is not, please, you are not appearing, then please don't say anything. Please.
Compression appointment.
Yes, he was saying that some child is ill, he is undergoing treatment, and if it is not taken up, he will be deprived of something. So what is the issue? His claim is for compassionate appointment. So that means there is a deceased employee.
2 wives are there.
How many?
2 wives.
2 wives, all right.
He is the second wife and my land friend is the first wife.
And they have children. Both
We
of
have
them.
2 children, Lordship.
You have 2 children.
We have 2 children.
Yes.
One is suffering from anorectal.
We didn't ask you that. Yes. So you have how many children? So 3 children. Is any child deprived of their retirement dues? They are getting proportionate.
Retirement benefits will go to the first wife.
And the second wife, the children are not getting anything.
They have got.
Please be sure.
Equally.
It has been distributed equally. Now, what is your? It has been distributed equally.
Lordship, my issue is
It hasn't
been distributed equally, Lordship.
Where have you said in your OA? Show us from the OA that you have not received anything by way of retirement benefit. Show that averment in the OA. You have gone through the brief.
Yes.
You know that the OA is not there.
Way is not there.
Lordship,
What are you looking for, sir?
Lordship, the way have not been
So,
annexed by.
where is that averment that nothing has been paid to these 2 children? Show us from anywhere.
Lordship, we have.
Please show us from the pleading, sir. Don't make submissions in air.
Lordship.
You have tried to invoke sympathy of the court by saying that nothing is being paid and treatment is being hampered. Where is that averment either in the writ petition or in the way? Show us. Then whatever submission you want to make, you can make.
Lordship, in our petition in para number 17, Lordship, page number 12.
Yes.
The petitioner number 1 has got 50% of the group insurance gratuity amounting to 4,60,000, but was denied to get any sum on account of Provident Fund, General Provident Fund, arrear family pension and other pensionary benefits of the said deceased husband employee.
Page
12, para number 17, Lordship.
And what has the petitioner number 1 got?
Lordship, the petitioner number 1 has got on behalf of the petitioner number 2 and 3 50% of the group insurance only, Lordship. That is
all.
That is all, Lordship. And report was
Family pension has not been apportioned between you.
no, Lordship.
Let us see what the tribunal has said.
Lordship, and report was called from the state respondents in this regard.
What is your prayer in the OA? Give us a copy of the OA.
Lordship, currently I don't have the brief
Then
of.
sorry, we cannot help you. If you are not prepared, what can be done? You should not have mentioned if you are not prepared.
Lordship,
Very unfortunate, such mentioning. Yes, you give your opposition.
Lordship, these are our affidavit in reply, Lordship.
We don't know how you will proceed without copy of the OA. We don't know. A futile listing was prayed for, unfortunately. Trying to invoke the sympathy of the court.
Lordship, please give
And
us.
yourself, you are not prepared to argue the matter. Yes.
Lordship, please give us a last and
Sorry, now it will come after the holidays. We can't help you. If you are not interested, what can we do? What is your prayer in the way? How do we know?
Lordship, it's written in our petition, Lordship. I have mentioned it in our petition, Lordship.
You have a copy of the OA. Mr. Mukherjee, you have a copy of the OA.
But I have got instruction, the first wife, Mita Mondal, got family pension, leave salary, 4. And the rest benefit divided into 4.
Lordship.
Rest benefit. Mita Mondal, first wife, they has been given
What has the first wife been given?
family pension and leave salary. First wife. And the rest benefit. 4 equal shares. First wife.
Rest means GPF, PF and what else?
Group insurance.
Group insurance. GPF and group insurance. So why the pension has not been apportioned between them?
But because marriage is in.
Forget about marriage. We are not asking about the marriage. How they can be deprived the 2 children?
Under the, when the option was exercised,
Why did you give the GPF and pension insurance to them?
first wife will entitled to get only one of the family pension.
Under which provision? Show us.
Seven, small e.
Rule?
Seven,
DCRB.
income return will be good.
DCRB compilation is like, it should be here. Rule?
Seven, small e. 1. Pension only wife will get.
Rule 7E.
7, small e.
Yes.
Family includes the following relatives of the government servant, namely for the purpose of death gratuity, wife in case of a male absent, husband in case of a female. Then 7(2). For the purpose of education, wife in case of Second one, there is no entitlement of second wife.
Hmm?
There is no entitlement of second wife.
No, no, we are not asking about the second wife. Why the two children are not getting?
Children will get only, but if they are minor, but then minor family pension, one family pension. There cannot be two family pension.
Who is saying two family pension?
Pension we are providing to the.
They are not asking for separate family pension. We are asking you, if there are three children, you have paid one retirement due to them, the other two, recognizing that they are born of the government servant, then why the pension has not been apportioned?
Pension, there is no such provision. The rule does not permit. Can you see the rules are
7 does not bar.
language?
What you are saying is it does not permit. That's a different thing. We are asking you, where is the bar?
Family includes the following benefits of the government service for the purpose of death gratuity to wife in case of a death after.
So where is the provision to pay the group insurance and gratuity to them, GPF to them?
That would be treated as a property of the
That would be?
would be treated as a property of the deceased employee. Pension under the scheme, but other benefits that would be treated as the property of the deceased employee. Deceased employee. That's why they will be divided into
Whatever anyone is getting now is in lieu of the services rendered by the deceased employee.
we are providing family pension to the first wife.
Why they are not, why they are being deprived of the benefit? Where is the bar that if they are married out of a second wife, they will not get?
There is no such provision of apportionment of family pension.
Lordship, please come to paragraph 15 and the P9.
You have mentioned this thrice in the last 20 days. And you have not bothered to complete your file to argue the case. We don't know what kind of service you are giving your clients, sir.
I apologize, Lordship.
You should be sorry.
I
Yes.
apologize, Lordship. Lordship, please come to paragraph 15 of the.
Before you invoke the sympathy of the court, at least you should have done your part.
I apologize, Lordship. I deeply apologize, Lordship.
Yes, what is it?
Lordship, by one purported letter dated 15 June 2023, the reserve officers of the Special Task Force Kolkata Police notified the petitioner that being the second wife, she can't get any family pension benefit of her deceased husband. But it was further notified therein that there is a provision contained in West Bengal Service Debt-cum Retirement Rule 1971, where the son of a government employee is eligible to get family pension benefit in case of permanent physical disorder. In this respect, a certificate is required by a medical officer not below the rank of a civil surgeon who certifies that the disorder is such a nature to prevent him from earning his livelihood even after attaining the age of 18 years.
What are you reading?
Lordship, paragraph 15 of the writ petition, Lordship. It's also, the letter is also annexed in the writ.
Show us the letter. Where is the letter?
Lordship, annexer P9, Lordship.
At page
85, Lordship. Page 85, annexer P9, Lordship.
The child is above 18 years.
No, Lordship. The child is just 4 years, Lordship.
Then why are you showing this? How this is relevant?
Lordship, it shows that the children are entitled to get the family pension. What they are
It does
denying,
not,
Lordship.
sir. Very sorry. It does not show anything of that sort. You are assuming something which is not there. There must be some provision, must be some departmental instruction. The children, once you have found that they are entitled to one due, how they can be deprived of the other due? You cannot recognize and de-recognize them at the same time.
First wife got everything. But when you get.
It doesn't say first wife and second wife. It says wife, it says children, sons. It does not say son only born of the first marriage.
Wife means wife.
Forget, we have not asked you about wife. We are why the other two children should not get. We are not asking you about the wife.
Death gratuity, and GPA.
And see the kind of problem this child is going through. Have you seen the brief? He is required to be treated. And you know that he is son of the government employee. Because you have given some dues. You can't say that you don't know.
No. So what children are concerned, it may be, marriage may be fine, but children will.
That is why we are not asking about second wife. We are asking why they should be deprived, why he should be deprived of the treatment.
Because what are under the Rule 7 only.
Rule 7, there is no bar. We don't find any bar that the. Yes.
He must be included in the definition of family.
They are sons. How they are not included in the family definition of family? Both the children are sons.
They are illegitimate child.
Huh?
Second marriage is fire. That's why.
We are not on the second marriage. They are sons. So why how they are excluded under 7E15 3. 3 says sons, including a stepson. Yes. So there is no.
They have got a death gratuity proportionate share.
That is why we are saying it is not that you have deprived them of everything. It is not your case that they are not son of the government servant. Otherwise, you would not have given any dues. So,
Because,
which rule provides for giving gratuity and provident fund to the second wife? Show us.
fancy small e one for the purpose of death gratuity, wife in case of a male officer, husband, including.
It does not say wives. It does not say wives. So why you have given? So why you have given? That's why we are asking you.
No. We have given sons, including staff.
Correct. So now sons. So if they are sons, then why pension should not be given? Pension also same thing.
Wife in case of a male officer.
Yes. And see rule small 3.
All three minor sons, including adoption.
Same as the one. There is no distinction. There is no difference in the two provisions.
Never been said about illegitimate child.
Hmm?
It has never been said illegitimate.
No, in one also it has never been said. There is no difference. Your discrimination or your distinction has to be founded on maybe a distinguishing feature found in the rule. There is no distinguishing feature.
I just put submission, but there will be one PPO, one family pension, whoever may be. That means when first wife is getting, if I wants to divide the other son, then division of the PPO, that is not permissible. Only one pension.
You have never done it in any case. You have done it. You have done it. There is no distinction in either 1 or 2. They are both couched in the same language. No iota of difference. Just maybe an inconvenience of issuing a direction to the treasury to make a separate payment. That inconvenience,
Then there should be a true PPO.
that's why we are saying maybe an inconvenience, but there is no bar.
On condition, pension,
There must be a provision. Some department.
is, rule 101.
101.
Then 102. Committee of the South Government Service. And rule 100 is nomination. There cannot be a nomination other than.
Sir, everything you are saying after you have paid GPF and gratuity, group insurance, then you should not have paid anything. You cannot blow hot and cold at the same time. You cannot say that they are entitled to certain benefits because they are children of the employee and other benefits they will not get because they are not legitimate children. That you cannot say. So you cannot issue two PPOs, that we understand. There is no provision. Otherwise, there is no problem. When you have given one dues, why the other due cannot be given?
Because it's the estate of the deceased employee.
Huh?
Family pension is not estate of the deceased employee.
And then who it is in lieu of service rendered by whom? This family pension is in lieu of service rendered by whom? So what do you mean not the estate of the employee? They would not have an individual right to this if he had not served you.
If there was no settlement, there would not have been a difficulty. Pension taking it off. After this, like
By one child, second by two child. And which provision regarding issuance of PPO? And why you are not cooperating with the treatment, sir? Have some consideration. Yes, why the treatment is? Yes, you may more than one thing. Yes. No, if you have copy of the OA, tell us. This. Huh. We don't know. They have withheld the OA from us. They have challenged that order. We don't know. That is an order under challenge. Everything it says cannot be taken to be correct. But that is the order under challenge. Why should we rely on that?
No, what I am saying, or the purpose of compassionate appointment, but who are eligible?
We are not on that. Whether there is any prayer or not, how can we find out unless we see the way? Whatever is recorded in the order of the tribunal is now subject to challenge by them. So we cannot take it that it is correct unless we verify.
Paragraph 21, I
Please mute him.
Lordship kindly takes up page 15 of this petition. They have set out what has been the prayer.
Paragraph?
Lordship, page 15.
What they have asked for and what was the prayer before the tribunal. The prayer was for
Compassionate appointment.
compassionate appointment. Now, my lord, they are digressing the issue. They have put those photographs just only to seek the sympathy of the court. Similarly, as they are in this
So what is prayer A?
Lordship. Yes, Lordship.
Please read.
court in correcting the matter, so that after beginning this for the sake and paramount interest of the minor sons, it is possible to certain the applicant for the sake and paramount interest of two minor sons, that is possible of that completion for the deal. Now, my lord, this I
B,
think
B.
so. Or this service
Not might be, this is so.
is so.
Yes. Yes.
They are ultimately asking for.
Forget about it. It cannot be confined. That means the tribunal has not considered this prayer. It should have.
What is
There appears to be an infirmity in the order passed by the tribunal.
the prayer was
It is good that you pointed out. We thought that we were also of the view. That is why we were asking him, where is the way? That if they have approached for compassionate appointment, how they can seek any other benefit? But it is clear now. They have sought other benefits. The tribunal has not even considered this. It has not even recorded that there is any prayer like this.
we are having for them. No, but we have to go by the statute. What the rules are. Now, my lord, during this substance of
Yes, Mr. Mukherjee.
I submit my
After him,
my lord,
not right now. Sorry, let him sub.
please, my lord.
Not required. We want to know the state stand, then we will hear you.
So, and I
This prayer has not been considered. This prayer has not been considered by the tribunal. You have filed a reply before the tribunal.
No, state has not. At the admission stage has been reached by order number 2.
Very unfortunate. You get some instruction.
Yes.
It is not that you have not apportioned. In one case, we have seen you have apportioned between the two wives and the children.
although the tribunal
Why
has given some thought on it, and the tribunal has recorded that they have been paid their benefits of gratuity and GISs.
You
That
take
has been
you
there.
take instructions on this. You come back. The affidavit in
since your lordships have recorded in the order that their child is suffering from disease, I have also annexed documents to show even my child is also suffering from disease.
Call the next.
Lordships may kindly records it, my lord.
We'll consider, don't worry. We have
Item
taken
number
our
two.
opposition on that. You, without hearing, you will not
Fine,
pass
fine.
much.
Item number 2.
I beg to appear, my lord. It is for some correction incorporation in the order, my lord. এটা authority direction and kind of framing of time frame.
What is to be mentioned?
Respondent number 2 may be directed and with a time frame, my lord.
What is it that you want?
My lord, respondent number A, an authority may be directed with a certain time frame, my lord, to disburse the payment, my lord. My lord has been pleased to allow the writ petition.
What is the date of the order?
My lord, order 29 July 2025. It was soon after uploaded. It has been mentioned with notice, my lord. Is the notice, my lord.
They have to make payment of interest till date of payment, so they should be in a hurry.
Maybe, but
They delay 6 months, you will get more
my
interest.
lord, until my lord, if time is fixed, my lord, that will
When a time is not fixed, what is the inference?
and an authority may be directed to.
So what is the meaning of the order today? Because the time has not been fixed. How long they can take for making the payment? According to you?
But if they do not, my lord, then I have to, my lord. If my lord fixes time, my lord.
So
after
therefore,
that-
we are asking you, what is the difference? If
But
we have not
after-
fixed a time, what does that mean?
After that, I can come back in contempt, my lord.
And
Otherwise,
this way you cannot.
my lord, if fix, my lord, 4 weeks, my lord, then my
And if we have understood, we are asking you, we have not fixed. So therefore, no contempt will lie.
contempt will lie, my lord. I have to wait for
No,
1 year, my lord.
You have to wait for 1 year.
My lord. So for my understanding of.
So
Thank
where is that law? Show us that
Lord.
as per this law, if we don't prescribe, you will have to wait for 1 year. Therefore, we must prescribe.
So much. My lord.
Whenever a time frame is not fixed, the law is very clear. It means a reasonable time.
my
And
lord,
they are to pay interest till date of payment.
yes, my lord. To my lord. An
So-
authority and maybe directed to.
Sorry, it is
particular
not there. You did not make a prayer. It was not done. What can be done? Why should we fix a time? If you could have prayed that day, that you
My
fixed
lord,
a time,
so far my subject to correction, my
you
lord.
were appearing.
I appeared, my lord, or my lord, dictation, my lord. So far I heard, I may be wrong, my lord. At time it was mentioned in the while dictating the order, my lord. Perhaps this has not been gone.
We don't think so. The order is clear in what it
Lord,
says.
by that time, my lord, perhaps my lord, 6 or 8 weeks time was dictated, my lord. Perhaps in the typing, my lord, it may be.
I give instruction now.
This order you have challenged.
I have no information. I should pass out.
What is the direction to pay on what ground?
My lord, that casual employees, my lord, pay. That was refused, my lord. On that ground, my lord, writ petition was filed.
Huh?
Enhanced remuneration.
Enhanced remuneration. So difference has to be paid.
Not on enhanced remuneration, difference and entitlement. They say, my lord, by the impugned order, they say, my lord,
You filed an application.
No.
Then how it can be done to be mentioned? Unless you file an application, how it can be done? We thought that you have filed an application. File an application.
এটা 2 নম্বরে 2 নম্বর
Adding something to your.
হ্যাঁ
You file it, mention after filing. When you will file it?
my lord, the client is staying in my lord in Balurghat, my lord. You have to
When you will file it, therefore we are asking you. Tomorrow, Monday, Tuesday, whenever you file it, mention after filing. Without application, we are not going to do.
আসতে পারবে না তো, বালুরঘাট থেকে আসা মুশকিল। I will try to communicate, my lord. His client stays in Balurghat, my lord. It is in far distance. my
We are asking you how much time. We are not concerned where the client stays.
lord. Within a week, perhaps, my lord.
File it. The
Possible.
learned counsel for the which one? Same. Same.
One week পরে item number 3. Item number 4.
My lord, in item number 4, I am for the petitioner, my lord. My lord, this is my affidavit of service. My lord, this issue is a very well-known issue, my lord, regarding the refund of excess payment inadvertently made by the bank to the pensioner or the family pensioner. Now, bank wants to recover at this juncture, my lord, whether it is permissible or not. There are several decisions. Even there is a decision of the special bench of the Honorable Special Bench of this Honorable Court, where my Lord Justice Bhattacharya was also a party to that judgment. Renuka Sarkar's case. I was, my Lord, had the occasion to even appear in that matter, my Lord. My Lord, may I be permitted to place my case, my Lord, in this matter? Here, my Lord, the petitioner before my Lord is the bank, my Lord.
You are for the bank.
I am for the bank.
Yes.
My Lord, here the crux of the matter is, my Lord, the petitioner's husband was the pensioner, regular pensioner. He retired in the year 1984, and he also died in the year 2000. Thereafter, the family pension started in the name of his wife.
How long was the wrong payment made?
My Lord, for more than, my Lord, 2006 it started, and it was detected in the year 2018. And from 2000, it was, my Lord, from the year 2000, 1st March 2000, we started deducting, and we have already deducted.
How you can start deducting from 2000 when it has been discovered in 18?
My Lord, from 1st March, sorry, my Lord, I'm sorry, my Lord, I stand corrected. From 1st March to 2018, we started deducting.
1st March
1st March 2018.
2018.
My Lord.
So for 12 years, you did not realize that you are making an excess payment.
That is what is on record. That is on record, my lord. But my lord, we are well aware.
What is the amount of excess payment?
My lord, excess payment amount was 1,66,624.
Entire amount. This is the total
This is the
amount.
total amount.
And you are making recovery at what rate?
My lord, we have already deducted. Till date, it has already been deducted, my lord. And he is getting a pension. She is getting now a pension of 19,135 presently.
What was the recovery per month?
Per month recovery was, my lord, 4,365.
4366.
My lord, 4,365.
So tell us what is wrong with the
We
order.
are all aware about the Rafiq Mashi's case, my lord. The 5 principles that they have laid down. One, my lord, has also already, my lord, is tracking my lord's conscience, my lord, that we are recovering it for so long, because there is a rider in Rafiq Mashi that 5 years is the rider given in the Rafiq Mashi. But my lord, at the same time, my lord, kindly appreciate that even in Rafiq Mashi, Chandi Prasad Uniyal, all these cases, my lord, one factor was that even our honorable special bench, the judgment was passed where my lord Justice Bhattacharya was a party to that judgment. Even he authored the judgment. My lord, the point was iniquitous. Whether it was iniquitous or not, when a person is getting a pension, first point is this, my lord, and second point, my lord, in that case,
So the special bench of this court will prevail over Rafiq Mashi?
Not at all.
Then,
but considering Rafiq Mashi, that judgment was delivered. In the light of Rafiq Mashi, that judgment was delivered. And my lord, there are 3 cases, my lord. In this Renuka Sarkar's judgment, my lord, there are 3 cases. Out of these 3 cases, 1 case was allowed in favor of the bank. First, there is one point of difference, what perhaps that was not before in the judgment of Rafiq Mashi, my lord, that there is a declaration or an undertaking by the family pensioner itself, not even by the husband of the family pensioner, that if anything is excess is paid to her, to which she is not entitled, she is bound to refund, or the bank is bound to deduct, my lord. There is an undertaking is there, my lord. My lord, kindly seize this judgment, my lord. There are 3 cases which were dealt with in this by our honorable special bench, my lord. My lord, may I take, my lord, to the second matter, that is the State Bank of India versus Shumita Bhadro. My lord, in this matter, the similar thing was there. There was an undertaking from the pensioner, not from the family pensioner, but from the pensioner. My lord, kindly seize paragraph 27, my lord. My lord, may I read?
Just give us a
My-
minute.
my-
So how this special bench decision is at variance with Rafiq Mashi case?
My lord, only the point of undertaking. In Rafiq Mashi, my lord, this point was
Where is
not
the
there.
answer to the reference, sir? Where is the answer to the reference? The special bench has answered a reference.
Reference.
Where is that answer?
My lord, that is not with me.
It is there, sir, 33(1).
33.
And what does it say? Please read.
My lord, the reference connected to WPA 18830 of 2022 is answered as follows: bank falls within and or is required to act in terms of paragraph 18 of the state of Punjab versus Rafiq Mashi, since the condition enumerated therein cover all stakeholders associated with the sanction.
So what
This-
is the answer?
My lord,
Answer
this
is
reference was
that you are not at any different pedestal than the employer.
my lord.
The same thing will apply to you.
My lord.
The onerous conditions stated in para 18 of Rafiq Mashi
My lord.
case will apply to you as it is.
My lord, kindly appreciate.
Now the next two replies are with reference to that case. Now
This
that
is-
case, you please read it with para 28 of the judgment at the top of that page.
In the instant appeal, the husband of the respondent was not serving as an employee belonging to class 3 or class 4 service or group C or group D. Instead, was working as a wing commander. In this context, it would be inappropriate to mention that the respondent himself was serving as a teacher.
Thereafter, she was also serving as teacher.
So there was no.
So
she
in
did
that
not
case,
suffer
there was no case of onerous condition.
onerous condition.
So going by Rafiq Mashi, the special bench has answered in this case that will not apply.
But, my lord, this
But Rafiq Mashi will apply to a bank also that the special bench has said.
Rafiq Mashi will obviously apply to
Yes.
bank, my lord. But kindly sees the reference which was answered in WPA 18830.
We are not concerned with that because that is why we are saying that is
Yes.
in the facts of the case. That is not answer of
This
the
is not
special
my
bench.
18830 is not my case. This is not the case of this this which was answered, my lord. This was answered in paragraph 27, my lord, is in a different case.
Yes.
Sumita Bhadro.
Yes.
My lord, where the only distinction is the undertaking.
Read
Undertaking
27.
was given.
Yes,
My lord, kindly, my lord, may I be permitted to
Yes,
place paragraph
please.
27? Considering the judgment passed by the Honorable Supreme Court in case between High Court of Punjab and Haryana versus Jagdeep Singh, comprising of Honorable Justice T.S. Dr. T.S. Thakur, Honorable Justice D.Y. Dr. D.Y. Chandrachud, wherein the Honorable Court, Apex Court, has come to the finding that the principle enunciated in Proposition 2 of the Rafiq Mashik cannot apply to a situation such as in the said case. In the present case, the officer of whom the payment is made in the first instance was clearly placed on notice.
Based on notice and gave an undertaking, both.
Here also, my lord. Here, not only the officer, the family pensioner herself, the petitioner, the private respondent herein, my lord. She gave an undertaking.
So what does that mean? You will continue to make a wrong deduction or make an excess payment for 20 years and then you will start deducting. Where is the equity, sir? You are a bank. You are subject to an annual audit. This fiscal discipline is supposed to be maintained by you. And you will continue to make this payment for 12 years and say that, look, now I have made a mistake. Now you suffer.
No,
A pensioner and 4,000 odd amount you are returning, recovering from per month. Her total due is about 18,000 or something. And from that 4,500 you are recovering per month. Unique.
My lord, kindly see, I am also placing reliance on Chondi Prasad Sunial case, my lord.
Yes, show that also.
It is there in 115, my lord.
Show that also. There is an annual audit being conducted in a bank. Why should you continue like this for 12 years? We can understand 2, 3, 4, 5 years. And you are not a government. The government is not bound by such strict fiscal discipline as you. They don't have to maintain the accounts in the way that a bank is required to be.
My lord,
You will continue to make the payment for 12 years and then you will say, now we have committed a mistake. We'll start recovering. And the amount you have fixed is such high. If you have continued for 12 years, you should have recovered in 12 years. That 12-year recovery you want to make in 2 years.
Oh, my lord,
Your mistake which you have committed for 12 years, you wanted to suffer in 2 years.
Not in, my lord, not in 2 years, my lord.
That's what you have done.
No. From 2018 we started. When this way was filed before the planet.
When it was filed?
In the year 2020.
23.
20. At that time, 89,000 was still pending. So ultimately, it stopped deducting. What I have, my lord, my instruction is this, my lord. November 2022. November 2022, stopped deducting.
So
4 years.
Yes.
For 4 years, we deducted, my lord.
Why did you not spread it over 10 years?
For 4 years, we deducted, my lord. That is
why? What was the basis for keeping it in 4 years, returning it in 4 years?
And my lord, kindly let me place, my lord. The decision of Unial, Chandi Prasad Unial is there, my lord, in my lord's brief, my lord, 115. Because 100? It was a part of 115, 115. Because it was a part of my written submission, notes of argument before the learned tribunal.
150.
My lord, the relevant paragraph is paragraph 7, which is at
115.
115, my 115.
In Unyal's case, according to you, there is no scope for considering a hardship.
No, obviously there is. Obviously there is. I will not say that, my lord.
Then
But my lord, can you see it has emphasized on the point of undertaking, my lord.
it has, but it has said except in cases of extreme hardship.
But here, my lord, only there was a pleading of extreme hardship. There is no such
And what are they required to show?
specific awardment. These are the things which happen. These are the events which are happening.
That we
which is
can
causing
consider very
extreme
easily.
hardship. There is
That
no
we
such
can
pleading, my lord.
consider very easily.
Hardship can be said by anybody. Anybody, even if I had deducted 100 rupees, even that could be would be said that yes, the amount of pension which I'm getting is very meager, and after that, if you are deducting 100 rupees, it is causing hardship to me.
Yeah,
So vague term, totally vague, my lord.
where is the OA?
My lord, I have annexed. Way starts from page 28, my lord. 25, my lord. 25. I'm sorry. 25 onwards. The facts of the cases are starting from page
And the
32.
tribunal has not passed any order in respect of the other claims.
My lord,
Benefit of 7 CPC fixation and all that has
No,
not been.
no.
Only this aspect.
Only this aspect. My lord, kindly says, I'm showing, my lord, the paragraph where the averment of hardships are there. My lord, I have served, my lord, but I do not know, my lord. Kindly cease, my lord. My lord, cease by affidavit of service, page 4, my lord, at the bottom. Item delivered, my lord.
Served once again. Let it be served once again.
I will serve 1 second. সঞ্জয় দাকে এখনই বলে দাও। হ্যাঁ, শুরু করো।
Item number 5.
And I am for the petition, my lord.
I am for the respondent.
The petition before your lordship, Union of India, my lord, railway, represented by railway officials. Here, my lord,
What is the issue?
we are aggrieved with the judgment and order of the London Tribunal dated 27th May 2025. Issue is very small before the tribunal. Why you are aggrieved? My lord, these entire proceedings are is arising out of one disciplinary proceedings conducted by the railway authorities. But the fact, in short, the fact remains that the respondent, only one respondent, who was the chairman of railway recruitment cell. Allegations against the railway or this chairman or the respondent that while he was acting as the chairman of the railway recruitment cell, entire examinations and recruitment process was entrusted on him. But he was supposed to set out the question papers and etc. and sending it to the printing machines and etc. and to get the question sets and distribute amongst the examiners. Now, allegations against him that while acting as a chairman and while setting out the questions papers, there is a leakage of questions papers. So, a great offense according to the examinations. As a consequence,
So the allegation is that while he was chairman, paper was leaked.
paper was leaked.
Not that he has leaked the paper.
But that has been established by the inquiring authority, by the disciplinary authority through the inquiry proceedings. He was party to that this misconduct because he deputed one the printing company who was involved in connivance with the chairman. The question paper was leaked out.
There was a criminal case also.
But there was no such criminal case. But as a consequence, the railway authority had to take re-examinations of the amongst the employees, the candidates, and as a we spent more than 6 crores, 6 crores for this conducting the re-examinations. So then, show cause notice was issued. The only one charges had been framed against him, that wrongful act, etc., and there is a negligence to default his duty, etc. These were the only one charges and one article of charges. Well, the inquiry proceedings was conducted. When the charge sheet was issued, challenging the order of charge sheet, but a first OA application was filed before the Central Administrative Tribunal. The tribunal, my lord, since the charge sheet has been challenged, tribunal said very well, we are not standing on the way of conducting disciplinary proceedings. You continue. Railway authority has been directed. You continue the disciplinary proceedings, inquiry, etc. But inquiry proceedings shall be concluded within 3 months.
Yes.
Here is the cause of action is arising out of. In terms of the directions of the tribunal, the inquiry proceedings has been commenced. Inquiry proceedings was continuing, and after obtaining the inquiry report, the authority, disciplinary authority, sought for the opinion of the higher authority, and accordingly, higher authority communicated to the disciplinary authority to dismiss him from service.
No.
Sorry, I stand correct. For reduction in rank.
Or deduction in rank.
Stoppage of
two pay scales.
Two increments.
2 increments. Only stoppage of for 5 years.
Not cumulative.
Not cumulative. But after that, Millard.
So that's a major punishment.
That was that is not the major punishment. That was not the major punishment. Subsequently, he suffered the punishment. Now the fact remains. Here this interesting fact is this. But when after obtaining the inquiry report, he did not prefer. But after conducting the inquiry proceedings, but when the railway authority or disciplinary authority obtained the views of the higher authority regarding imposition of the penalty, then he moved further away without preferring the statutory appeal. He moved further away application through the tribunal. Only on the one ground that disciplinary proceedings is part and should be set aside on the ground that as per the first way order, passed in the way applications, that within 3 months, that was beyond the time, as time frame fixed by the tribunal. So therefore, disciplinary proceedings was concluded beyond the 3 months time, as framed by the tribunal. We are agreeing with that. Firstly,
Tribunal has allowed it.
tribunal rejected my MA applications. We sought for extension of time. That was also rejected.
No, when he filed an OA that it has
That's first way.
My lord.
when he filed an OA that now it has transgressed the time limit, they should not be permitted to proceed. Then you filed an MA for extension of time.
No, that was not the order. Order was my only in fast way, order passed by the tribunal to conclude the disciplinary proceedings within 3 months.
That we have understood.
Right. Second
You
phase,
say that in the process of getting advice and instruction, it has crossed the limit.
3 months.
Then he has
Then
filed a second OA.
Second, we took out MA application.
Then we have taken out MA application.
MA application
In the
in the
earlier
earlier
one.
one. In connection with
In
the earlier,
earlier.
Two MAs was filed.
only one MA.
One for
No, I have not filed anything.
oh, you have filed.
I have filed. I
Railway
sought
has
for
filed.
extension of time to conclude the disciplinary proceedings. The order of the tribunal was that we are rejecting this MA applications because it is time barred, firstly. Secondly, now it has become infructuous because already you continued the disciplinary proceedings on expiry of the 3 months, not you.
How long?
But 4 months more. We took 4 months more.
Only.
Only.
More than twice
The
the
order was passed on 31st January 2019.
2019.
Yes.
Order was passed on 30th January 2019. We moved MA applications in July 2019. July, May.
My lord, may I cut short it? Because I was in the council before the tribunal. 31st January, the OA was disposed of with a direction to complete it within 3 months. The order was, the certified copy of the order was communicated to the Railway Authority on 21st February 2019. They have filed a MA application in the month of July 2019. So the 3 months gap has covered. After that, they have filed the OA application, and they moved the OA application in November 2019, just after the day the order of punishment
Some
was
dates are
passed.
relevant. Let me finish.
Sorry.
Some dates are.
I'm just assisting.
No, yes, very good. In July 2019, we moved the MA application. We sought for extension of time. Tribunal, my lord, was pleased to reject my MA application only on the ground it is time barred. Secondly, you did not follow my timeline, the guidance which was given in the order. And this order was passed by the tribunal 29 November 2019. But in the meantime, on 26 November 2019, prior to the final order passed by the tribunal, the disciplinary authority had passed a final order of punishments. That is reductions in 2 ranks, etc. That was on 26 November. Tribunal rejected my application on 29 November. So then, my lord, he didn't prefer any statutory appeal. But in the meantime, from the day that is on 26 November 2019 till for next the period, he suffered the punishments. He didn't challenge at all. Now, after 2 years of that order dated 29 July 2019, whereby the tribunal rejected my MA application, he has come before the tribunal.
MA was not rejected in July. MA was filed in July.
Filed in July, but it was due to paucity of time. However, the tribunal could not take up for the hearing.
So it was finally decided in November.
Decided in November 29.
Yes.
But penalty order was passed on 26 November. He suffered penalty from.
That we have heard that
Yes.
prior to pass the.
Yes.
Yes.
Now, after 2 years, since 2019 till 2 years, 21, 22, perhaps in OA application has been filed and challenged only on the one ground. That is, disciplinary proceedings bad in law because it was conducted beyond the time limit fixed by the tribunal. I am agreed with this order, which has been passed on 27th May 2025. But a very short order.
On his OA.
On his way. Tribunal said.
When your MA was rejected, you did not challenge it.
He has accepted that order.
We didn't prefer anything. Neither read petitions or I also incur from my client's office. No. But here, we are agreed. The law is well settled. I am covered by one Supreme Court decisions arising out of this Calcutta High Court, whereby Supreme Court said that if any order fixed or the timeline given by the tribunal, either or High Court, that is not the mandate or that should not be any statutory or it should be flexible. It is not the mandatory that the authority should comply within that time or conclude that time. That is I am covered by Supreme Court decision.
Lord, I am also covered by a Supreme Court judgment. That is mandatory.
Every service স্লিপটা দিয়ে দিয়েছো? আচ্ছা, thank you. এই কটা বাজে? এটা কি গো? ও আচ্ছা, ঠিক। কি জিনিস এটা? ইভেন্টস।
Everything has been exchanged.
But
Reply, rejoinder, everything has been
it
exchanged.
is there. It is we have annexed here. But
Everything.
here, but we are praying for lordship the stay of the operation of the.
No, I am objecting to it.
Because also what I am covered by Supreme Court decisions.
No,
But
I am
one
also-
decision recently delivered by Supreme Court, but this case one has went from this Calcutta High Court on the same issue. Stay of the because tribunal directed the last paragraph the railway authority to give the consequences because tribunal was pleased to set aside the interdisciplinary proceedings. And my lord, the already punishment suffered, but set aside the interdisciplinary proceedings and directed us to give the payback is that remunerations,
My lord,
which was reduced.
my lord,
Lordship.
I am objecting
page 59.
59.
Article of charges 1.
Sorry, which page, sir?
Page 59.
Page 59. ওয়েতে ছিল না। এন্টার ওয়েট অ্যাটেন্স করেছি তো ওটার মধ্যে নেই, আমরা আলাদা করে দিই। বলেছিলাম যদি অনেক বুঝতে পারে। My lord, only point of law before your lordship, my lord, my humble submission for your lordship's kind consideration whether the holding or disciplinary proceedings beyond 3 months is valid or not.
That we have understood. The point in issue we have understood.
But
We
I'm
want to
grateful
know
to
the
you,
background.
The only, but
We just
background,
want to see the background.
yes, but because he never challenged other things, the whether the interdisciplinary proceeding is bad or not on different grounds, nothing. Not even prefer any statutory appeal.
And where is the inquiry report?
But neither they have annexed nor we. Because that was not the challenge in anyway. Only thing
So
beyond
then let
three-
us see the first order passed by the tribunal.
Yes, my lord.
Page 68.
Page, my lord, at
68.
68. Relevant is paragraph 5. Yes, page 69. Tribunal, while passing of this order, never said so that beyond 3 years you should not hold the disciplinary proceedings. So it was not the mandated to conclude the disciplinary proceedings beyond 3 months. There was no such restrictions imposed on us. And it can't be mandate.
So what is the date of service of this order?
21st February 2019. That was served. That was decided in the order of the tribunal.
Next page, 70, the order of rejections of my MA applications for seeking extension of time. Dated 29th November 2019. And page 73, one of the final order which was passed on the respondent, that is on
No,
26
it is-
November
what is the
2019.
date of service of the order?
20, so which order, my lord?
20,
Service of the first order of the tribunal.
21st February 2019.
That is not in dispute.
That is
that is not.
It was served on which authority?
All the respondents. Because during course of hearing, the tribunal was pleased to ask for the entire record from the department, and the entire record was placed before the tribunal, wherefrom it transpired that it was served and they received it on 21st February.
Page 73, final order was passed by the disciplinary authority.
Operative portion is at page 74.
26 November 2019. Paragraph 6 is the relevant portions of the penalty which was imposed on the respondent.
Extension of time MA was 119 or 475? What was the number of the MA?
Extension of CAN number MA 475 2019.
And what is 119?
119 condonation of delay. No, I think so. For a moment. 475. 475 is for extension of time. Second MA filed by the respondent.
So that is what we were asking you when you were arguing that MA was filed from both sides.
My Latin friend said no. Yes,
We thought that perhaps both sides would have filed.
Really appreciate your response.
Let me check up whether it has been filed by me.
Your OA was filed.
That was the MA of 2018.
20.
Of what?
Of what?
Prior to.
prior to, most probably it is relating to condemnation of delay of such kind thing.
This order was
Condemnation of delay, we don't think so.
31st January, yes. At the time of moving.
2018. In the way of 2017. Maybe it's for, sorry, early hearing.
Early here.
Early hearing.
Can't be for condemnation because it has been filed within a year.
Within a year. Thank you. So early hearing and actor question.
And 2611 order is, where is the 2611 order?
2611 at page 73.
Page 73, your lordship will find it at page 74, the relevant portion. Paragraph 6.
Page 85, further promotions after serving this penalty has been granted to the in favor of this respondent.
Because 6 months period has been
Page 85, dated 6 July 2021.
Because 6 months
After
period
serving the penalty period. Further promotion was granted.
No, it is not 5, it is only 2 stages.
no,
Two
two
stages.
stages for 6
For
months.
6 months.
And only 6 months.
6 months.
Only 6
He
months.
had suffered for 6 months only. Promotion minor.
So this punishment order of 261119 does not even have any reference to OA number 1146 of 17.
No reference has been made.
So the railway board does not consider the tribunal even worth considering in the order.
Because railway board, because main order was passed on way in 31st January 2019. Thereafter, disciplinary proceedings continued and ended on 26 November 2019 because no further revision was prayed for. So therefore, here the disciplinary proceedings has been concluded.
So they did not
And
even bother
after
to
that-
consider that the tribunal has passed any order. Railway board
Yes,
is so
it has not been mentioned here. Yes, admittedly, it has not been
kind of
mentioned.
order
But
they
it
have
is,
passed.
everything is on record. Everything was on record.
That is
when
what
the-
we are trying
what
to
was the
see.
direction? That's why railway board sought for went back to the tribunal and sought for the extension of
But
time.
it did not consider
It was
anything.
very much
that
within their
the
knowledge.
Tribunal's order is irrelevant.
No,
for
it
the
was
board.
very much within their knowledge. Well, my humble submission. Otherwise,
In spite of that, they are not mentioning. Just see the conduct.
not mentioned. Not mentioned.
What is this GM or railway board? What do they think? Is it?
They didn't mention here.
And this is the only fact now.
Only facts.
And what is the present order? This was by them challenging the order
By
of punishment.
challenging the order of punishments and enter disciplinary proceedings only on the sole ground that it was beyond time. Therefore, it should be set aside. It is not valid. And tribunal was pleased to set aside the entire disciplinary proceedings with the further directions to restore the consequential benefits to the applicant within a period of 3 months. We are agreed to that extent only.
Who has been filed in 22.
22.
22.
My lord,
After 2 years.
my lord, after 2 years, my lord, what's it kindly come to page 139. The
The Supreme Court decision, the
Supreme
Suamoto
Court decision.
proceedings, which had been, the order has been passed by
Therefore,
the Supreme Court during COVID.
139.
The order was passed in November 2019.
No, which page you are trying to show?
139.
130.
1?
39.
That Supreme,
Last paragraph.
that's matter pertaining to COVID.
Oh,
So motu proceedings had been.
Therefore, that 2 years delay, the
WPC 3.
Yes. Three.
So therefore it was considered to be
So,
within.
sir, I'm not pressing on that. That is not the major.
2
issue.
years will not come into effect in this.
Now, State Governor, kindly come to the conclusions of the order, which is at paragraph 13.
My lord, it's elaborate judgment, Lord. Kindly see the
Paragraph
judgment.
13 is the conclusion.
Everything is there.
But I shall rely on one Supreme Court decisions on this point. This case went to Supreme Court from Calcutta High Court also on the same issue. 31, দিচ্ছি। Reliance has been placed on para 31 onwards. Para 31, me write it out. Para 31, it needs, if the sentence begins with, it needs hardly any elaborations to say that fixing of the period of 2 months by the tribunal in this case had only been to ensure expeditious proceedings because the matter was being restored for reconsideration in the year 2010. Though the disciplinary proceedings related with the incident noted 9/1/2005, however, the said period of 2 months did not acquire any status akin to that of a statutory mandate, that the disciplinary proceedings would have automatically come to an end with its expiry. It remains a treaty that if an adjudicating authority in exercise of its jurisdictions could grant or fix a time period to do a particular thing in absence of a specific statutory provisions to the contrary, the jurisdictions to fix such time period inheres the jurisdictions to extend the time initially fixed. Such conditional orders have regularly been construed by this court to be interim so as to put a check on the dilatory tactics by any litigant or to guard against any laxity on the part of the adjudicating authority, but the court is not powerless to enlarge the time even though it had peremptorily fixed the period at any earlier stage. In case of Mahanath Ram Das versus Gangas Das, so and so reported, this court examined the peremptory order of the court fixing the date of payment of deficit court fees in the backdrop, so and so. 32. We may elaborate a little. While a conditional order is passed by the court or tribunal to do a particular act or think within a particular period, but the order does not provide anything as to the consequence of default, the court or tribunal fixing the time for doing a particular thing obviously retains the power to enlarge such time. As a corollary, even the appellate court or tribunal or any higher forum would also be having the power to enlarge such time if so required. In any case, it cannot be said that the proceedings would come to an end immediately after the expiry of the time fixed. 33. In the present case, even the order dismissing the applications for enlargement of time on a technical ground of not placing before the tribunal instructions of the railway board had again been not of giving any such status of mandatory and rigid character to the period originally fixed that the proceedings would have abated. We are impelled to observe that while treating the proceedings as having abated and as nullity, the High Court has ignored the fundamental principles that fixing of such time period was only a matter of procedure with an expectations of conclusions of the proceedings in an expeditious manner. This period of 2 months had not acquired any such mandatory statutory character so as to nullify the enter of the disciplinary proceedings with its expired. However, when no consequences of default was stated in the order dated such and such, the period as stated therein was only of expectations and not of mandate. We may also observe that very many times such fixing of time period causes more complications and harm rather than serving the cause of justice. Fixing of such period could only be justified if there are strong and compelling reasons for the same, and if at all such period is proposed to be fixed, not only the reasons for the same but even the consequences of default are also required to be stated if such period is for any valid reasons expected to operate with adverse consequences on the defaulter. The upshot of the discussions foregoing is that the proceedings in the questions neither abated nor could have been considered nullity only because of passage of the expected time period stated in the order of the tribunal dated such and such. There was no reasons or justifications for the High Court to interfere with the just and proper order passed by the tribunal on so and so date. which deserves to be restored and necessary consequential benefit. 37 is not relevant. 38. Accordingly, in view of the above, impugned order certainly set aside. So, here in a given case, these things, the similar facts is also been approved. That tribunal said within 3 months to conclude the proceedings, but did not say so that what would be the consequence if it is not concluded. So it was, therefore, it was not the mandate.
My lord, my learned friend has relied on a Supreme Court judgment. My lord, I am also, it is a judgment of 2022. I am relying on another Supreme Court judgment of 2025.
So, Ram Prakash, yes.
Lordship, kindly straight away come to paragraph 62. That is page 54 of the judgment. While affirming the aforesaid view, have your lordship got it? Paragraph 62. Page 54. ये दाও না টিকারটা দাও না
বেশিক্ষণ না। ওটার জন্য বলছি। তুমি হচ্ছে আগে যেতে হবে, আগে গিয়ে এক্সটেনশন চাইতে হবে, ততক্ষণ বসে থাকতে হবে। তুমি ফেব্রুয়ারি মাসে সার্ভ করেছো, আর গেছে কোর্টে জুলাই, তখন 3 মাস তো ফেব্রুয়ারি, মার্চ, এপ্রিল, মে, জুন, জুলাই। কিন্তু তুমি যখন ওই অর্ডারটা ক্যাট দিল 31 জানুয়ারি, তার আগে নভেম্বরে তো হয়েই গেছে, এই সরি 29 নভেম্বর
সেটা
হয়ে গেছে। পরে করা যাবে যদি কনসেন্ট দেয়, এটা অ্যাকর্ডিং টু দিস জাজমেন্ট। বাট এটা দেখি কনসিডার করেছি কিনা এই জাজমেন্ট।
এক্সপেরিমেন্টসটা কি কনসিডার করেছে?
ওটা প্লেসড হয়েছিল কিনা দেখি।
না প্লেস হতে কিছু করার না। No? May I read out for your lordship?
অভিষেক
Full bench decision.
কোনটায়?
Union of India versus Swatandra.
Not been considered. I now I found. I'm also searching on it, but I didn't find out that whether Salman Kumar was considered or not. Not considered.
My lord, in that aspect, my lord, another thing is that in page 54, Union of India versus Swatandra Kumar Sahai, that has all not been considered in Savan Kumar.
Yes.
This judgment is his latest judgment. My lord, this judgment has also quoted another judgment. Also, kindly see page 54 at the top. At the top. On the basis of this observation, they have this court has clarified it. That is the judgment of 2005. Pardon, my lord.
Please read para 63. You are stopping at 62.
Continuation of the
We also held that the continuation of the disciplinary proceedings beyond the time stipulated by the tribunal could invite interdiction if no bona fide attempt is shown have been made to take extension of time. However, much would depend on the fact of the each case. My lord, kindly see, on 21st February, the order was communicated.
Fix it after the holidays. Get some more judgments. We'll see, because
Let us come up.
there is an apparent,
More preparation.
yes,
Yes.
because 62 and 62 is primarily what we were of the view 62 says.
Yes.
Because once a time is fixed, whether it is to be,
Otherwise, concept of filing application for extension of time goes.
no, his lordship has said that even if the application is rejected and you are proceeding simultaneously, another issue has arisen. It is a case of bias.
Price of bias.
Forget about time bound. He says when the time has lapsed, still you are continuing. So it is a case of bias. Why should you proceed? When the time has lapsed, you halt the proceedings and you wait for the verdict in the miscellaneous application. So everything has to be seen.
Right. Lordship. In the meantime, I'm praying for stay.
No,
Yes,
I am
meantime, we will direct.
God's grateful.
Otherwise, it will become infectious. Yes.
That will become
Heard the
important.
learned advocate for the railways.
Nothing will remain. Grateful to you. That's it. And he got promotions. He's working.
no. It was for 6 months. Obviously, he got
Yes,
promotion.
that's
Actually, the
As you know.
sufferings was from the time. No.
In the meantime,
My lord,
that's
he has missed 2 DPC for that. Because when the disciplinary proceedings was continuing, it was in his entire APR was kept in envelope, sealed envelope. He had missed one DPC in the month of July, and in the month of that also culminated.
that's good.
And six.
That's
And six.
Ballot, I am for the appellant ballot. petition.
WPCT.
WP, WP.
Yes, please.
Ballot, first, my apology that I could not serve the notice to the respondent authorities properly. However, Ballot, the matter relates to the refusal of the compulsion appointment at the death of my father. I am the married daughter, my lord. And due to that, they refused grants compulsion appointment in favor of me.
So let us see what is wrong with the tribunal's order.
Tribunal order is at page number, my lord, end of the volume number 2.
So married daughter should be granted the compassionate
My
appointment.
lord. My
Let
lord.
us see the rule. Which rule
My lord,
permits?
the rule, I have cited the rule 248. RB 70, 248.
Where is it? Page?
Second one, 248. 248, my lord. The second volume, my lord.
So this is the RBE on which you are relying.
My lord.
You are relying on this RBE.
I am relying on this, my lord. My lord.
Where is the rejection order?
My lord, it is a first rejection order is at page number 214, my lord. By the JMP Jamalpur, my lord. CWM, Chief Works Manager.
And your representation?
Well, my representation is at page number. Different time I have submitted different representation starting from page number 96, 196 onwards, my lord.
Where is the representation of 13/7/23? 13 July 23 representation.
13 July 96, my lord.
96.
23, my lord.
13 July 23. Where is that? Which page?
Page number 196, my lord. My lord, before that, page number 188 is the Hindi version also. The application is there. Representation.
Yes.
188, page number 188 in Hindi version also there is some representation. In the year 2018, my lord.
What to be done with page 188?
188, my lord, in Hindi, my lord.
Yes.
Sir, Hindi, I am very weak, sir.
Is
My lord.
able to understand very well, but
आवेदन पत्र की
सदस्य सरकारी या सेमी प्राइवेट गवर्नमेंट और सेमी गवर्नमेंट स्वर्गीय पिता की मृत्यु के पश्चात हम नौकरी से नहीं करना चाहते तो acknowledging of the life to be actually and if their the agreements
Or there is one more representation of 2017. 1711. Where is that?
oh here it is. The 171 for form application. Yes, ma'am, sir, you have marked it.
So 170 is,
Yes, it is at page 192. There are two representations you have referred to in your representation. One is at 192 and one is at 188. So this is the rejection which was challenged before the tribunal. And what is the date of death of the mother?
mother 21, 22. 21, 12, 22.
Not 21, 20, not 22, 21 perhaps, somewhere.
21, left and right 21. 21, 12, 21.
So after this representation of 2017 and 18, you have filed this representation in July 23.
Yeah. Not the 240 the death policy it's up to my
We'll hear you.
Original side listed matter item number 1 with two.
My lord, rollover matter is it? Item number 6. My lord.
Take up that matter first when the time is fixed.
Written side application. Audio side.
Yes.
It will be passed after the completion of the original side matter, the judgment.
Oh, I see.
Which makes
It will deliver.
will be delivered after the completion of the original side matter.
I won't take long, my lord. It's just questions of.
There is no, see, I don't know the precedent here. I asked his lordship. He said that first we have to take up the fixed matter on the original side. Supplementary will be taken up later. So why do you have to ask? If this is a system, it will come after this. Yes. Yes.
I will take. My lord, there are two sets of arguments. My lord, I'll only deal with the questions of all, my lord, which have been raised. One is, my lord, first, my lord, I go with the private respondents, my lord, submissions. My lord, that there has been, my lord, a change, my lord, in the policy pursuant to, my lord, the letter of 3rd of January 1994, which is, my lord, at page 595, my lord, of, my lord, volume 18, my lord, of, my lord, APO 114. Or, my lord, if your lordship takes the Reserve Bank of India violation, my lord, it's at page 51. Now, my lord, you kindly please, my lord, the 1992 Act. My lord, the 1992 Act, my lord, which was handed up.
'92 Act.
If that was given separately, my lord. Separately, the 92 Act. There is the Foreign Trade Development and Regulation Act of 1992. It was handed up on the 30th of July 2025.
Must be there.
Yes, sir. And I have a noting.
We remember seeing it.
My lord, I have one extra.
Actually, generally the person who is here, he is not here today.
My lord, my lord, kindly bear
It
with me,
must
my
be
lord, I
there
have
in-
only one copy, my lord.
We will, yes. Just give that and in the meantime, you look for it.
My lord, it's been found. My lord,
Yes.
kindly come to, my lord. My lord, this is, my lord, the Foreign Trade Development and Regulation Act 1992. Now, my lord, it's kindly see the preamble, my lord. It is an act for the development and regulation of foreign trade by facilitating imports into and augmenting exports from India and for matters connected therewith or incident to it. My lord, this is not, my lord, an industrial policy at all. My lord, it is the what we refer to, my lord, as the export-import policy. My lord, what imports will be banned? What will, my lord, be the tariffs, my lord, on certain category of imports? My lord, what exports would be permitted, etc. Now, my lord, kindly come to Section 5. My lord, Section 5 says, your lordship kindly takes it because 3rd January, my lord, cannot be, my lord, a policy under this act. The central government may from time to time formulate and announce by notification in the official gazette the export and import policy and may also in like manner amend that policy. So, my lord, a mandatory requirement, my lord, is a publication, my lord, in the official gazette. For, my lord, any amendment, my lord, of, my lord, what we refer to as the EXIM policy. That has, my lord, not happened. So, my lord, 3rd January 1994 cannot be, my lord, treated, my lord, as an amendment, my lord, to, my lord, the policy. My lord, this is a well settled proposition, my lord. If publication is mandated by the statute in the official gazette, my lord, it has to be done. Otherwise, my lord, it's of no consequence.
And that is dated 3rd January.
94, my lord. It's at page 51 of the Reserve Bank of India compilation. And, my lord, at page 595 of volume 18 of the paper book. It's an internal communication of, my lord, the Ministry of Finance and, my lord, the Reserve Bank of India. And, my lord, Sri Chaudhary, my lord, is, my lord, the Deputy Controller, my lord, which your lordship will find, of the Reserve Bank of India, the next page. My lord, I had, my lord, in law, my lord, made my submissions on this document.
Yes.
I'm not, but what, my lord, what was argued, my lord, was, my lord, as if, my lord, this was a change in policy pursuant to the 92 Act. My lord, it is not. Now, my lord, the second point, my lord, that is, my lord, the lordship takes. Now, my lord, Reserve Bank of India has handed up a note. Now, my lord, kindly take, my lord, page 12, my lord, clause C. This is, my lord, an argument. Now, my lord, your lordship kindly notes, my lord, we had contended that this DO, my lord, of 3rd of January 94 was never disclosed, my lord, during the course of any proceedings, or, my lord, before, my lord, the, my lord, controller, my lord, Reserve Bank of India. Now, that is admitted. Kindly see RBI's response, that it's a policy directive and the issuance of shares against importation of second hand could only be on such a condition imposed on company was only for the benefit. Consequently, non-furnishing of the letter to Shojol could not have caused any prejudice for issuance. Now, my lord, with the greatest of respect, my lord, the impugned order also says, my lord, that the order, my lord, prejudices. My lord, the learned single judge's order records, my lord, the prejudice. And the, my lord, kindly take, my lord, this approval, my lord, is under 19 and 29. Your lordship sees, my lord, the main, my lord, dispute is, my lord, increase of common shareholding, my lord, in the company.
Yes.
Now, my lord, if common shareholding, my lord, increases pursuant to this, my lord, I lose, my lord, my negative control, which is, my lord, 25%, over 25%. And that is noted also, my lord, in the order of the learned single judge. To say, my lord, that this doesn't cause prejudice to me, with the greatest of respect, my lord, is, my lord, not correct. Secondly, my lord, this case which has been relied on, Chip sees, my lord, case की compilation है ये जो my lord, 2010 5 Supreme Court cases 349. My lord, this was, my lord, a service matter. My lord, this really has no application at all. In, my lord, disciplinary proceedings, my lord, there was, my lord, a document, my lord, what was complained of, my lord, in the disciplinary proceedings, my lord, if your lordships take para 76, that, my lord, the Central Vigilance Commission report and notes, my lord, had not been, my lord, circulated, and therefore there was prejudice. Kindly come to para 76 when it says there's no prejudice because this was not the basis of the order. Kindly come to page 375, para 76.
Yes, unless such notes were actually considered.
Correct. It wasn't. Unless such notes were actually considered and had some prejudicial effect to the interest, it will not be necessary to the court to interfere in the department. So, my lord, with the greatest of respect, my lord, this has no application. Second, my lord, your lordships, my lord, being told, my lord, there are two policies here. One is, my lord, the industrial policy, and the other, my lord, is the exempt policy.
Now, my lord, I had argued, my lord, that industrial policy itself, which is the main policy, because who will come in and do business in India is determined by industrial policy. My lord, what can be exported and imported is determined, my lord, by EXIM. Now, my lord, industrial policy itself said that, my lord, if, my lord, any, my lord, equipments are to be imported, and it's a particular paragraph, 39B3, which I had placed, which says, my lord, that the import has to be of new equipment. Now, admittedly, that is not so. I had also relied on EXIM, that even if it was merely export and import, my lord, which we are concerned with, my lord, for capital equipment, it had to be new. And, my lord, if it was not new, certain conditions had to be met. I had shown your lordships, my lord. My lord, volume 18 of the paper book, page 575 for the industrial policy. The 39B3, your lordships have that, my lord. I think your lordships had marked it also.
Yes.
39B3, my lord, is what? And, my lord, under, my lord, 3 of that, your lordship sees of the notes, note number 3, foreign investment must cover the cost of imported capital goods, which must be new and not second-hand. Now, my lord, this 39B3 was admittedly operating, my lord, at that point of time, and the company had got approval to do business on this basis, to bring in, my lord, foreign funds, my lord, on this basis. This has not been changed. My lord, then, my lord, I had also relied on, lordship will find, my lord, at page 580, my lord, 585 of that very volume. I'm sorry, my lord, I had also relied on, my lord, 580. Kindly have a look. My lord, right-hand column. My lord, this is all part of, my lord, industrial policy. Investments in priority industries under 100% scheme. My lord, kindly see 3.
You are stressing on A.
Correct. Correct. Now, my lord, this underwent no change. My lord, later on, my lord, industrial policy, it's opened up, my lord, the sector. Now, my lord, the EXIM policy which I relied on was at page 585. My lord, I had made twofold submissions. My lord, one is, my lord, simpliciter import. My lord, kindly forget about industrial policy. If a capital equipment, my lord, is being imported, my lord, it had to be, my lord, new. My lord, saying second-hand capital equipment will not be imported. But, my lord, 25 also provided that second-hand capital goods with a minimum residual life may be imported by actual users, but, my lord, certain declarations have to be made in a prescribed form. Now, my lord, my learned friend, my lord, kindly come to page 44, my lord, of the Reserve Bank of India compilation. As, my lord, said, my lord, that, my lord, what I had cited to your lordship, my lord, was not, my lord, the prevalent import policy. Page 44. Where, my lord, 24 was not there. Lordships have that, my lord?
Page 44, yes.
Yes, kindly have a look at, my lord, my learned friend showed your lordships, my lord, page, my lord, 49. to say 24 has been deleted.
Yes.
Now, my lord, my first submission is that doesn't affect, my lord, the approval granted, my lord, by under industrial approval to do this business, because NRIs are coming in, foreigners are coming in for the purposes of doing business, for which it's the industrial policy. But, my lord, this 24, my lord, gets deleted. Kindly have a look at page 44. It has an amendment, my lord.
Yes, up to 31st March 95.
Correct. Now, my lord, what I relied on, my lord, my lord, the full document I have. My lord, kindly have a look. My lord, just the first page. My lord, import started, my lord, under this policy.
Yes.
Not, my lord, after March 1995. My lord, 4 consignments were before, 3, my lord, were after. The records show that. And, my lord, the answer, my lord, regarding clause 25 is that since customs cleared it, everything must be okay. My lord, the Reserve Bank did not go into the question at all.
Yes.
Kindly have a look at, my lord, para 40. My lord, page 30, my lord, of, my lord, volume 1 of APO 114.
Page 30.
Yes, my lord, of volume 1 of the paper books.
Yes.
That's separate.
Not the convenience compilation.
My lord, this is, my lord, our case was this declaration not given. Reserve Bank, my lord, filed an opposition. My lord, in, my lord, private respondents compilation, it's there at page 69. Lordships, if your lordships have that, your lordships can also see. My lord, the Reserve Bank has not, my lord, dealt with this at all. Their affidavit.
From here only, from the volume 1 only.
My lord, the private respondent.
Page 30, we are at page 30.
Yes, page 30, para 40, my lord, kindly see. The respondents 1 to 3 in purporting to issue the said communication so and so will to appreciate that respond number 6 had caused petitioner number 1 to import equipments without causing a declaration to be submitted to CUB with regard to import by concealing the facts that equipments were second hand. My lord, it's only if a disclosure is made that it's second hand. My lord, would a declaration have to be filed that it has a residual life and price is reasonable. And my lord, the declaration, my lord, we showed to your lordships, my lord, page 588 of that volume 18, my lord, which is with your lordships. Page 588. Lord, Appendix 11, form for furnishing declaration by importers of second-hand capital goods as required under the policy. Kindly see note, please see para 25 of the policy and para 41. We do hereby declare that imported by us as per details are in and have a minimum residual life of 5 years. Description with technical, etc., name of manufacturer, year, present condition, so and so, then CIF value. And my lord, it says, under that the above statement, information, etc. are correct. And my lord, if it's 1 crore and above, my lord, your lordship seen 585, the importer shall furnish to the customs at the time of clearance a certificate from an internationally reputed inspection and certificate to the effect that the purchase price is reasonable. And my lord, even that, my lord, is, my lord, given, my lord, here, my lord, the list of inspection and certification industries, pages 588 and 589. Our case was this is not complied with. My lord, kindly, my lord, have a, my lord, Reserve Bank, kindly take it from me, my lord, because it's not there in the, I can't show it. My lord, they have not dealt with it at all. And my lord, the private respondent, my lord, it's unfortunately not there in their compilation subject to correction. Ache, aorta, nahi. My lord, kindly take para 31 of their affidavit, my lord, which is at volume, my lord, 11 of the paper book, page 1631.
Which page?
My lord, 1631. Kindly take 1631 first. My lord, this is, my lord, paragraphs 34 to 40. Lordship finds. My lord, at 1632, last 6 lines. Para 40 is the last 4 lines. It is denied that respondent number 6 had done or caused the petitioner company to do anything improper or illegal or material fact was concealed or so and so to unjustly enrich himself. My lord, I had made a similar charge, my lord, in my lord, para 10 of the petition, which is at pages 11 to 12 of volume 1. Similar allegation, pages 11 and 12. My lord, this is also dealt with, my lord, in that same volume, my lord, 11, page 1622, at my lord, paragraph 13. ITC para 13, 1622, with reference to para 10, it is denied and did not make it known to all concerned that medical equipment obtained and denied and disputed. Respond number 6 caused the entries. If indicated in the account is denied and disputed. And my lord, apropos, my lord, this policy, my lord, which has been referred to, my lord, kindly just have a look at, my lord, the order and what has been submitted before your lordship. My lord, page 307 of volume 16, my lord, order touch it record. Take it out. My lord, convenience compilation also has it of, my lord, the respondents. Kindly come to, my lord, page 18. My lord, your lordship recalls, my lord, the High Court order, 3, my lord, issues had to be decided. High Court order said this is a real fight, my lord, between brothers. Now kindly have a look at, my lord, page 275 of the private respondents compilation. Kindly see second issue. Your lordship has that. Now kindly see whether the approval shall be on non-repatriation basis alone. As discussed above, equipment supplied by so-and-so was second-hand. Company had received and utilized the same for which Doctor had made payment abroad. Since as per the existing policy of RBI, it's not, my lord, industrial policy, not exim policy. And what's being argued, my lord, first, there was a change in policy under 1992, which is, my lord, just exim policy. It's not that.
So you had said which policy?
Correct. There's none. Industrial policy doesn't change it. The entire investment business was commenced on the basis of industrial policy, which requires, my lord, certain conditions to be fulfilled. Lordship's right, my lord. I said which policy was this?
Yes.
And what they come out with is, my lord, that order, and they say this is a first, my lord, industrial policy, which it is not. Exim policy, which it is not, because it has to be gazetted. And second, my lord, it can't be industrial policy. My lord, those are my answers. নোট দিচ্ছি না দিচ্ছি না My lord, the Reserve Bank's given a note. If your lordships want, we can give a short note.
Shall, my lord, yes, we could not prepare it
Yes, my lord, next week.
next Thursday. Bye. We shall,
No, no, no. We'll, my lord, we'll give a short note.
Thursday? By Thursday next month? We can give,
Friday সকালে এসে my lord, Thursday, my lord.
Yes.
শর্ট টার্ম থেকে তো এক্সাইটটা আছে না May we have your lordship's leave?
Yes, yes. Ah. मैं लगा दूं।
Let's start supplementary list item number 1.
Ah, yep. You are both for the union.
Yes.
Where is he?
Fine.
Was he here a short while ago?
But he was. No, we didn't see one of them. Sure.
He is aware of the fact that it will be delivered. The other side is aware of the fact that it will be delivered today.
But we have seen one supplementary list.
Supplementary.
On seeing supplementary list, we came alert.
Impugned order is modified to the extent that the charge memo, cancellation of the charge memo is paused.
We are partly allowing the writ petition only because the tribunal has also quashed the charge memo. So that remittance will be of no avail. So to that extent.
Good.
Continuing matter item number 6.
My lord, oh, they have taken only plea that the married daughter shall not be allowed to take the job of his father, of her father, deceased father. But rule as well as everything is supporting that she will get it. And there is a distinction between the married daughter and married son. Married daughter equally eligible for getting the, and not only that, her husband also deserted her. He does not live with him. And Panchayat issued the certificate in favor of her that she is depending on her father. After death, she was with her father, and after death of her father, she was with her mother. Thus, after death of her mother, she is the eligible candidate for the compulsory appointment on her father's death. Moreover, my lord, her widow mother applied before herself for appointing herself into the railway job. But railway did not allow her as because her age was overbearing, overaged. The basis of that, my lord, the railway rules as well as
that order of the railway that because she is overage, she will not be getting the appointment.
my lord, but as per page number 215, volume 2.
Yes.
Their findings, their speaking order. Page number, para number 5. As per Honorable Cat Patna, order date passed Kushum Devi has not considered after death of the Kushum Devi Atho. The applicant wishes, my case was not allowed by the Patna.
Just now you said that mother's application was not entertained because she has crossed the age.
Madam.
Where is that finding? In which communication by the respondent?
Where is the Patna High Court's order is there? Malad, I am coming to that. Page number 238, my lord.
Page number
238, volume 2.
230.
238. 38.
Now come to paragraph 4.
4, my lord.
Yes. Where does it say that she is overage?
It is meant to help a family to tide over the immediate financial crisis on account of the death of the sole breadwinner. In this case, the widow is now 55 years of age. She is the sole dependent. She has got substantial.
She has got substantial lump sum settlement and is getting decent family pension. Therefore, it is not a fit case for grant of compassionate appointment. It's not a case of overage. Therefore, we asked you. The High Court has taken into consideration that she is the only person left behind by the deceased. She has got a substantial amount of gratuity and all this lump sum. She is getting a decent family pension. It's not a case for compassionate appointment.
But
there is no order of rejection that you are overage, therefore your application is being rejected. You submitted, therefore we asked you from where you are submitting. Yes.
The question of
and this order of the Patna High Court was challenged by you?
No, my lord.
Then after this order, where was the occasion to make an application again?
My lord, as because she was there and I have the convenient here to come at Calcutta. I have the jurisdiction of Calcutta cat, my lord.
No, when the High Court has already held that it is not a case of compassionate appointment.
In case of my mother, it was.
So, all right. So this order was not challenged by you?
No, my lord. In case it was my mother.
And this order is passed on
My lord, the order passed on.
July 17.
Aye, my lord. July 17. My lord, moreover, they themselves admitted that in terms of the RB number 70 2000,
Then she has started. 17. 8. Pending. That she probably- You have taken 22nd May. 17th May.
no, but they admitted themselves that the cases of the dependent divorce, page number 215, my lord, again. The
They
question-
admitted.
They admitted that the married daughter is eligible, provided two conditions, madam, proviso. One is she will have to be dependent on her father, and second is that she will be the bread earner of the family. But
So bread earner issue is gone now.
gone now,
Yes.
my lord. But when I applied, that time it was, my lord.
Hmm?
When I applied my application, submitted my application, then the matter was there. I applied in the year 2017, and during that period, my mother was alive, and my mother died only 2021, my lord. During the case of that, second proviso was there.
So now she is not there. So therefore, where is the question of bread earner now?
My lord, from the very beginning, they have.
All right, that you have already said. But now where is the question of earning bread for anyone? She is not there.
My lord, in case of the married daughter,
And she was not required to have anyone to take care of her. The High Court has already held that she is getting sufficient. She does not require anything. Therefore, we are asking, where is the question of bread earner? For whom?
My lord,
High Court order, we asked you, did you challenge? You said no.
it's a cat order, my lord, not High Court, it's a cat.
Then what can you, that's why has the cat considered the High Court's order?
Right.
Let us see.
My lord, there shall be.
How your application was maintainable, that we are wondering. When there is a finding that she is not entitled to any maintenance, then where is the question of daughter getting anything? When the High Court has already recorded a finding she does not require anything,
Well, compulsion.
there is the question. What compassion?
Well, the compulsion appointment shall not be a single.
Let us see what the tribunal has recorded.
Particular points of event, my lord.
In the OA, did you disclose the order passed by the High Court? In your OA, have you disclosed the order passed by the High Court?
Cat.
Where is that? Show us.
High Court order is 238, my lord. Cat order.
You have stated about the earlier order of the CAT in your OA. Patna CAT order have you stated in your OA?
My lord, yes.
Where is that? Please show us.
238 page number
248.
238.
We are asking you, in your OA, have you mentioned about this order?
No, in a way, we have not stated.
That is why otherwise it would have been dismissed immediately without even notice being issued. So why you have suppressed this relevant fact in your OA?
So we have
So if then after Calcutta you go some in other state and you file another application before the CAT suppressing this order.
My lord, the matter was in regard to her mother.
Sir, have you disclosed or not? Please be very careful and tell us. Otherwise, such person is required to be dealt with appropriately. This is not a fishing game that everywhere you will.
Well, give me time. I shall be.
No, go through it right now. What time?
I shall be in a position.
You
to
read it right
that
now. There is no
properly,
question of time.
because I have not.
You are not. You are here appearing to argue and you don't.
Annex the matter in the way, but not whether stated or not, that will have to be seen. OA.
Other's address. What is your address in your application?
My lord.
In your application, what is your address? Come to page 101.
My lord.
Village Babudi in the district of Baka. Your address at page 101.
My occupation is village Budhi,
Babudi.
Babudi, post and PSA Bouncy.
Whose address it is?
Banka. This is a district Banka.
Whose address is this?
Banka.
Whose address is this?
My father address it.
Come to page 138. Your father was living in Jamalpur, not in Baka.
Jamalpur was a quarter.
Baka is a different place from Jamalpur, sir. You come to page 138. That representation which you have filed in 2018, when you say that you are fulfilling your marital obligations with your husband, in this representation you have said that you are living with your husband, in that the address is Babudi.
Babudi.
And in application also you are living with your husband, but you are saying that my husband has left me. What is this? And you are suppressing the High Court order. This is not expected.
Cat, my lord.
Yes, cat, whatever. That is an order. You have suppressed that order.
I have annexed the order, but I could not.
No, you have not.
state
You have not
the order.
annexed.
I have annexed.
You have not.
On 38, my lord, this is my case. 238, my lord. 238. My lord, 238. My lord,
238 is R by 2. Respondent must have annexed. The respondent must have annexed. Where is the reply filed by the respondent? That is not annexed by you.
Respondent reply, my lord.
It is R by 2. That means it is annexed by the respondent in the opposition. Now come to page 218.
218. It is there.
You have not annexed. Respondent has annexed in their reply, in their opposition.
For the application. Right. Right.
Yes. Suppression, misrepresentation, both.
My lord, let me to withdraw the matter.
You have instructions to withdraw.
My lord, my humble submission was that there is the difference, distinction between a son and daughter, but the material total facts was not totally known to me, my lord. Though it was facts.
See, the policy is very clear.
My lord.
Unmarried daughter can be granted. Married daughter can also be granted.
My lord.
If she is required to be given appointment for maintaining the person who has lost the bread earner, or if she is dependent upon the government. Bread earner issue is over because the wife is no longer in existence. Whether you are dependent or not, there is no scope to argue this. The cat has held that she was the sole survivor, sole dependent. That is the expression used in the cat's order. Once that finding is not challenged by anyone, where is the occasion to say, you have not placed it before the Patna High Court? You say that now I am dependent on my husband has deserted me. In the 2017 and 18 representation, you are saying that I am fulfilling my marital obligation with my husband. In that, the address is same which you have given in the application. So where is the question of desertion? Or that you have been left, or that you have been separated? Just see the facts. It is all there. But you, why do you, unless you get a written instruction, why you should withdraw?
Let me get a chance to argue to take instruction from my client, my lord.
It can come back on Monday. You get a mail or something by Monday. By Monday, we are keeping it. Not beyond that. We have heard everything. We don't want to keep it pending.
My lord.
We learned advocate for the. Ask whatever order.
Seven.
My lord, in item number 7.
Yes.
I'm praying for not this week as the affidavit of service is not ready. Though we have posted.
We have directed for service.
No.
Then you
This is
proceed.
motion.
Then we'll see whether service is required or not.
Lordship, I have been directed by Mr. Nilanjan Bhattacharya. He is the senior in this matter. My lord, kindly adjourn this matter for 1 week.
Well, it was extended December 20. This. We are directing the
Wait, I am for the petitioner. Here, I have initially challenged the order of transfer on the ground of the transfer issued by the competent authority. That was the ultimately rejected my petition. Your Lordship can come to page 133. The order starts from page 133.
who is the competent authority? You are working on which post?
I am working as an accountant under the director of
Head accountant.
director of printing under the central government.
Head accountant.
Accountant.
Accountant under the director P&T.
Printing. But the transfer issued by the director of director of publication. And first appointment letter kindly come to page 61. That is issued by the director of printing.
You are accountant in P&T, not in publication.
No. You will also kindly come to page 62 first. This is my appointment letter. Page 62. The Lordship top Ministry of Urban Development, Director of Printing. That is the appointment letter. Now there are transfer order also issued.
Where does it say P&T?
Yes, that kindly top Director of Printing.
Oh, printing.
Yes.
So printing is not part of publication.
No, publication. Well, there may be a different department under one ministry. Well, one but only one. Well, defense there are 3 wings. One wings cannot transfer the another wings persons. That is my call.
Where is the rule?
Rule of transfer here.
Yes.
That is at my lord. Thank you.
You have been transferred to which place?
And transfer from Kolkata to Delhi.
Delhi.
I'm initially in Delhi. Now they have been transferred to Calcutta.
Where is the transfer from Delhi to Calcutta?
That is yes. Page 51. Kindly come to page 51.
Yes. That is also by the same authority.
Yes.
That is also by the Directorate of Printing.
Printing.
So that you accepted.
Yes. I have no problem.
But this one you will not accept.
My now the transfer is to the Director of Publication.
Where is that?
That is that. Kindly come to page 103. Or below page 132. 31, 32. To the transfer. 132. Oh, 132, not 132. Transfer page 85. And it is not a routine transfer. In my
page 85.
This is used by the Assistant Counter Administration, Department of Publication at the top. Kindly see at the top, Department of Publication.
Where is the rule? Show us the rule.
Rule is, policy, yes. Policy. 100.
No, the competence of the transferring authority is to be found in the rule.
Yes. Yes.
Where is the rule? Who is your cadre
Yes,
controlling?
yes, I will give it. Page 59. Kindly come to page 59. It starts from page 59, relevant portion at page 60. Page 60. A, small a. Not so legible that I.
This is a transfer guideline. We are asking you
all previous transfer issued by the Director.
Where is your service rule? Where is your service rule? Forget about previous. Every day the nomenclature of department changes. It is not something new.
Can I bring it? It's service rule starts at no.
Page 60.
Today I have been released. Today I have been released. After issued in 2022, today I have been released as the matter is taken up for hearing. Today, that has been served in WhatsApp message.
You are here to argue a case.
Yes, my lord.
You are
Have
saying
received now?
you are saying that you have been transferred by an incompetent authority.
Yes, that is my ground.
You only have to show from the rule that he is incompetent.
That was also reflected from the order itself.
We are not going to see that.
That
Just because you say we will not accept
I
it.
am handicapped.
You will have to show from the rule.
Yes, that I have to. Today I am handicapped.
Come tomorrow. Not today.
Yes, tomorrow, my lord.
Ask him to. Sir, your brief is not, the second brief is not complete. There are some pages missing.
Sorry that.
You please check up.
Yes, yes.
You compare the two briefs.
Immediate copyright.
At least that much you can do right now.
Yes.
So if there are any pages missing, you can give it to us. And please tally it with your brief also.
Yes.
We don't know whether there are.
It can be considered. Okay, due to brief it.
29.
I will clip here on the. The petitioner before your lordship was suspended in 2013.
The learned AG was here short
Yes,
while
yes.
ago. If not today, ask him to come. Not today. Because he has to make submission. We have already recorded our prima facie view
Yes, yes.
in your favor. We don't know what will happen.
10. I'm appealing for the account engine.
I am for the petitioners. I am for the petitioners.
Petitioner.
Petitioner.
Yes.
Well, at one thing, your lordship will kindly consider whether the principal accountant general is a necessary and proper party.
What is
Because
his claim?
But the claim my
Claim is
family
against the
pension.
state government and approval or disapproval. We are the accountants. Why we are made a party? Because none of our inaction or overaction is because we cannot act independently.
Why didn't you get your self deleted before the tribunal?
But over here, everybody appears.
Now you are a necessary party. You could have done it. It is
Can we
done.
take out a miscellaneous application? Then your lordship will consider it.
Let
Over
us
here.
hear him what he has. Yes.
This is with regard to the dispute of my lord, the family pension of the petitioner. The petitioner, my lord, is claiming a wife of the deceased employee. My lord, his name was nominated as a nominee in the, my lord, the service book. Now, the, my lord, after demise of the, my lord, the employee, the petitioner, my lord, is paying the authority, my lord, paying the family pension to the petitioner. Now, the private respondent who is claimed the, my lord, the wife, he, my lord, filed an application before the authority concerned. He is saying that I am the first wife, my lord, so I am entitled to get full family pension. The tribunal, my lord, he filed an application before the district delegate court. District delegate court is directed, my lord, issue the other asset in favor of the, my lord, the private respondent. Who is the
Before which court?
before the district delegate.
For delegate.
District delegate court. My lord, the district delegate court, my lord, issued direction to release the, my lord, the other assets of the, my lord, the employee in favor of the respondent. Now the respondent has made an application before the authority concerned for providing him full family pension. My lord, this application was allowed. My family pension has been stopped, and my lord, the family pension was awarded in favor of the private.
Where is the order of the district delegate?
The order of the district delegate court is at, my lord, page 46, my lord.
46.
46. Annexure P4. Okay, nominee করেছে। ফার্স্টটাই ভালো। Start. It's too good. Then I cancel.
You did not challenge the district.
Yes, my lord, you have challenged the order, my lord, the misappeal number 623 of 2023. The next date was fixed on 17th of January 2026 before the district judge Purvo Mendipur.
Then before that, how tribunal can give it to you? That is all. We don't know. You may be, you may not be. Before that, how the tribunal can give it to you? So at best, you can reserve your liberty that after the order passed by the High Court, you may approach the appropriate authority or tribunal, whoever it is.
But I, my lord, the respondent, I am the, my lord, the appeal filed, this application was filed by the, my lord, the respondent was 6.
Yes.
My lord, he filed the application of succession. My lord, he obtained this order, and by virtue of this order, he made an application before the, my lord, the tribunal. In the tribunal, my lord, I was the respondent. The tribunal passed an order stopping my.
Therefore, we are saying what is wrong. How can you get anything unless that is set aside?
My lord, stopping my family pension. My lord, I am.
Because you are the second wife. There
My lord, I am also, my lord, the penniless. My lord, I am also the widow.
You may be, but where in the service rule there is no provision for grant to a second wife. See, in 75 she was married. 79. In 85 you were married. She has produced Aadhaar card, she has produced voter ID card, she has produced a marriage certificate. These were marked as exhibit. You did not cross-examine on these issues. The court held that those documents are valid. You admitted that your marriage is later than her. Court said, where is the question? Your marriage during her subsistence was not recognized by law. Therefore, the court issued the succession certificate in her favor. She staked her claim before the tribunal that how you are paying this person when I have been held to be the person authorized to receive the benefits. It has been granted. Unless that order is set aside, how anything can be granted to you?
Subject to customer, I am the nominee in respect of that.
Maybe.
I am the nominee. And my lord.
Where is that nomination?
The nomination that is at my lord page.
Where is the nomination? Show us.
Page 43, my lord.
So, does the service rule permit that nomination can be made outside the family?
No, because my lord, the employer, my lord, is recognized me as his wife.
Sir, does the service rule mandate that the family member has to be a nominee, or it permits? Just show the rule. Where is the rule? If the service rule says that anyone can be a nominee, then that issue may not be, we don't know. We'll have to see. This is a nomination.
Because, my lord, he has described himself to herself to be the wife. The nomination.
Employer is herself. Employer, my lord, is.
My lord, that is the
The employee, my lord, the employee.
This is not a nomination. This is the PPO.
PPO.
PPO, my lord, in the PPO, I was mentioned in a service book. Since I was in service book, my lord, I was made a nominee. The PPO was issued in my favor.
We are again asking you, where is that nomination? Saying the same thing 3 times does not make it more acceptable. You have to show. Otherwise, the provision is clear. Come to DCRB Rule 7E. You will see the persons who are eligible to get the pensionary benefits. 7E1 and 7E2.
May I just come back with this nomination document, my lord?
No. Whatever was before the tribunal, we will not travel beyond that, sir.
Yes, my lord, the tribunal orders, my lord, kindly see.
No, show us from the OA. In the OA that you have annexed the nomination. For the purpose of death cum gratuity, wife. And for the purpose of family pension, wife. It does not say wife stroke wives like it does in some other rules. Only wife, or wife in the case of a male officer, husband in the case of a female officer. Family pension also same thing, wife in the case of a male officer, husband in the case of a female officer. So unless you get something in the
My lord, kindly come to my lord, the tribunal's order, page 52.
Yes.
My lord, the second page of the order, my lord.
Yes.
While this start from while a direction was passed by this tribunal to the Treasury Officer Kharagpur to file a report stating the action taken by him in terms of the order passed by the learned district delegate. In his report dated such and such stated that the Treasury Officer, being the pension disbursing authority, pays the pension as per PPO issued by the Principal Accountant General, West Bengal. Presently, such a family pension is being paid to Ms. Munju Sengupta. The private husband was 6. The Deputy Director and the Subdivisional Land and Animal Officer, Medipur, being the pension censor authority, wrote to the pension authority and left the matter to be decided by the Principal Accountant General. So, in the nomination, I have been made nominee in respect.
We have not found the word nomination. We don't know from where you are reading it. Unfortunately, this word is now stuck in your head. We are asking you to show from the record.
May I just take trouble to your lordship, my lord, page 45, my lord.
Yes.
My lord is God, my lord, page 42, part 2, my lord.
45.
45, my lord. People, now kindly come to my lord, the clause 15, my lord.
Yes.
The nominee, as per the nomination of the payment of area of pension and rules 1986.
Yes.
My lord is got the my lord Monju Sengupta, and
Wife.
my lord this.
Yes. She has been. You are Manju.
Monju, my lord.
No, but it says. Who is for the state? You are not for the state.
At page 45, my lord, column 15, my lord, I have to take specific instruction on
Please
that.
do
my
that. That's why we are asking you.
lordship. Specific
Let
instruction.
notice be issued to the casually. But then you have to diligently get your name deleted. Otherwise, in every successive proceeding, you will be a necessary party. What can be done?
And that is adding to our list of pendency of cases. Though there is no direct list.
No, apart from that, it is a waste of resources because the office is having to incur, but diligently you have to take it up. What if you have not done it before the tribunal? Here he can't omit you.
Have to take out a miscellaneous.
So whatever, yes.
Appearance দিতে বলছে না দাদা, appearance চাইছে।
Lead each. Respondent number 4, Bhaskar Prasad Banerjee. Item 11 হয়ে গেছে নাকি? দিয়ে দাও আবার please. হ্যাঁ, page.
In this matter, my lord, I am appearing on behalf of the state respondent, my lord. No, my lord, state respondent, my lord. My lord. Lord, petitioner's grandfather was expired and my lord. My lord. And he made a representation before the Honorable Chief Minister on my lord 21, page number 53.
None appears on behalf of the writ petition. Take up the hearing. Next is hearing matter.
There is another motion.
Item 12.
Yes, Lordship. Item 12, Lordship, I am appearing, Lordship. In this matter, Lordship, petitioner is a Lordship professor and Lordship of radiology posted at Sagar Datta Medical College. He want to pursue Lordship postdoctoral certificate course, Lordship, only for 1 year. And Lordship already selected after obtaining NOC. And Lordship, he already got admitted, Lordship, at IPG MER, Lordship, under same department under the control of DME. Lordship, now petitioner applied for study leave that has been denied. Lordship, thereafter, Lordship, it is a second round litigation. First time petitioner, Lordship, filed the matter before the tribunal and non-granting of interim order by the learned tribunal. Petitioner appealed before your Lordship. Kindly come, Lordship, page number 79. This is your Lordship's order. 79, Lordship. Your Lordship ultimately disposed of this matter, but liberty granted that why only study leave? Petitioner can avail any other leave. Yes, that matter, Lordship. Your Lordship, observation, Lordship, your Lordship passed the order on 16/7/25. Thereafter, immediately thereafter on 87, Lordship, page number 81. Lordship, I have applied. Lordship, 81, Lordship, I have applied any other leave, including study leave. What is in my credit, Lordship? Thereafter, Lordship, matter has been, Lordship, finally disposed of by the learned tribunal. That is on page number 85. Tribunal, Lordship, direction given on 12/8/2025. That direction given to DAB to positively take a decision in terms of my application by 10th of September. Unless if the 10th of page 87, the DME rejected my fear. That is the impugned order, Lordship.
87.
87. Mainly, Lordship, on dot of doctor. But it is only for 1 year course, Lordship. I am under same umbrella. Within Kolkata, Lordship, I want to pursue my course.
University হয়েছে।
So then why are you here? Why have you not approached
No,
the
Lordship,
tribunal?
I have filed thereafter I have challenged the matter before the tribunal. But Lordship, your Lordship knows that Lordship tribunal is presently not functioning. I have Lordship filed this matter and Lordship kindly see the last. This is the order of the Lordship, last page of this 9 September Lordship 25. The learned Lordship, the matter is taken up. No bench is, since no bench is available. That's why Lordship I am approaching. It is Lordship urgency is there. Lordship courts already started from April 25 Lordship. Lordship, there is no bench available and Lordship, presently there is no member.
See, you have no right to a leave. If the service is required in public interest, how you can
No,
claim?
Lordship, what I am submitting, I am also annexing the relevant judgment of this Lordship coordinate bench. Lordship, study leave it is only for 1 year. Lordship, if I Lordship, I have Lordship already serviced more than 20 years for the department. Lordship, it is within Kolkata, from Sagar Datta Medical College to Lordship PG, IPG MER. Lordship, I can Lordship pursue on any condition. And Lordship, it is transferable job. Anyone can Lordship for temporary period. I should be Lordship.
That's not the issue. The issue is, do you have an enforceable right that once you ask for a leave, it must be
Lordship,
granted?
I can say that Lordship, this is my fundamental right because I can Lordship.
You can say that.
I
We
can
want to see that. We are not interested in your saying that. Where is the right? Show us the basis of your right to claim a leave.
Lordship, Lordship, it is only for higher studies, only for 1 year.
How many times you will say that? You want study leave, they have not given you study leave. Court said if not study leave, you can take any other leave and pursue your course.
Yes, Lord.
Now other leave also they have rejected. They say we cannot spare you because you are a doctor, we require you in public interest to serve. You say no, I must have my leave, I have a fundamental right. So show us the rule which says that once a leave is applied, it must be granted.
Yes, Lordship, I am already taking.
You will, there will be nothing remaining.
Lordship, may I just show Lordship, your Lordship. Rule on
Otherwise, what is the infirmity in the decision?
170. Lordship, Rule 170, I have also taken Lordship this point. Rule 170, Lordship, it is says, 170.
179 says that general, just read it. We have seen it in one case.
Lordship, 197.
197. What does it say? Please, please.
It is Lordship, leave may be granted to the government employee on such terms as government employee may be granted. General order.
General order. So where is that general order? This is the enabling provision for issuing general orders regarding grant of study leave. General order has already been issued by the government. So where is that order?
But initially, I have already admitted, initially they have allowed me to participate in the selection process conducted by West Bengal Health University. NOC has been granted in my favor. Plus, it is only Lordship, my innocuous fear, Lordship. It is only in any condition I want to pursue Lordship bond that I will serve. I will never resign. I want to pursue bond that I shall serve for my Lordship.
Go on leave without pay. Who is stopping you if you are so?
Lordship,
if you are so,
Lordship, I can pursue the courts, Lordship, for greater interest of public. Lordship, it is also.
So therefore, we are asking you, where is the general order? You are making submissions, general submissions, as if we are discussing an issue. We are hearing the matter with a view to decide whether you have a right which we can enforce or not. So the 197 says government may issue general orders for study leave. Government has issued general orders. We have seen in one case.
Yes, Lordship.
So under that general order, what is the right of a person seeking leave for study? Let us see.
On candidate.
Don't say he has got, I have not got. These things we don't want to see. Where is your right based on the general order? Show us.
Lordship, they have Lordship, another Lordship doctor also.
That's why now you cannot be spared. One doctor has gone. They cannot send all of them.
70 Lordship.
They may have.
But
They
Lordship,
may have.
this is condition that the
Maybe. We are not on that. Everybody does not have a right at the same time to abandon the government service. All doctors, if they all at one time are allowed to go on leave, who will perform the duty?
Lordship, it is, may I submit, Lordship? It is
You may submit, but you are not showing the relevant provision.
Lordship, anyone can accommodate from.
All right, then we'll decide only on the basis of submission.
Finally, see, Lordship, I am
Let us see.
also annexing two Lordship judgment.
So
Lordship.
we are finally deciding the issue.
Page number, Lordship, page number, Lordship, 89.
Yes.
Lordship, it is Lordship, page number 89.
Yes.
WPST 126, Lordship, my Lord Justice, Lordship, Holy Standard sitting with Justice Lordship Prosenjit Viswas decided the issue.
Yes.
There was a proceeding pending against
Which page, which
page
page?
89, Lordship, annexing that. Lordship, operative part, Lordship, page 90. Lordship, middle portion. Be that as it may, second paragraph. The attention of the courts was drawn that if the study leave is granted, the same may be served the purpose of and experience which is in service medical officer would achieve by pursuing the higher degree course would benefit the government and public at large. And Lordship, thereafter, Lordship, this doctor has been accommodated 3 years 10 reserve Lordship study leave. Thereafter, Lordship, another coordinate bench, Lordship, also passed following that order, page number 92. There was also proceeding pending against those doctors. Lordship, my case, I am Lordship coming absolutely in Lordship. There is no allegation against me, no vigilance case, no DPS pending against me. And page 92, Lordship, another order, Lordship, this is also WBST 126-23. On page 92, sir. ওই তো একটা দেখালাম আগে 89 দুটো আছে, দুটো অর্ডার স্যার। ঠিক আছে, এইটাই
General.
Lordship, your
Have been granted during pendency of the matter before the tribunal. Nothing has been decided. The tribunal will be free to take a decision.
This is not a final order.
No, Lordship, this thereafter, Lordship, matter has been Lordship finally disposed of by the tribunal. Lordship, studies he has
What kind of
continuing the
anyway, what else you want to show?
thereafter, Lordship, Lordship, another order also passed by this Lordship following that order. Lordship, page number 93. This is also WBST 126, but year is next year 23. It is another coordinate bench, Lordship, learned advocate, Lordship, appearing, Lordship, page WBST 126/2002 has been followed. Lordship, page 93, middle portion, followed by that earlier order, Lordship. This Lordship, the another coordinate bench also passed the Lordship same order and for passing the course. The general order. And Lordship, this is the general order, Lordship, I have found, Lordship, in the rules. বুঝেছো?
So this is what we told you. You go on study leave without salary. You are relying on a judgment in which the petitioner has said, I will not take salary.
Bias, and this is the general order.
So who is stopping you? You go on leave without salary.
Without NOC, I cannot pursue the course.
But that's not your claim. You want a leave. You don't want NOC.
That means, Lordship, they have to pursue.
When have you applied for NOC?
Yes, Lordship.
And where is rejection of NOC?
Lordship, I have applied, Lordship.
Where is the rejection of NOC? You want a leave. You have approached the tribunal for leave. Your application is for leave and the authority says we can't spare you. You are required for performing the duty of a doctor.
Lordship, page 53. And this is permission to appear, Lordship. They have initially allowed NOC, page 57.
Then NOC has been allowed.
No, NOC should to participate in the Lordship selection process.
So where is your application? You cannot enlarge this to everything in the world.
Yes, Lordship, in my application, Lordship, I have.
In your OA, what is your relief?
Yes, Lordship.
Show us whether you have claimed NOC or not. To begin with, we told you that who is stopping you? You may go on leave without salary. You tell them, I don't want any salary, I must pursue the course. You do it.
Yes, yes.
Who is stopping you? You can't claim a salary and enrich your education, and the service will not be given to the people. We don't know whether any provision allows this.
They will not, Lordship, allow me study leave. I will not get any salary. They can, Lordship, in my credit, there is sufficient leave. They have also, Lordship, know that fact. That there is a sufficient leave in my credit. That should be available, Lordship. In that case, Lordship. Lordship,
And you are making the same submission without referring to any rule which gives a right to avail the leave.
Lordship, I have annexing that, Lordship, my in.
Where is the prayer in your OA? And since April, the course is going on, you are not pursuing the course.
Lordship, they have not allowed me. Lordship, I have already admitted my every original document, Lordship, kept, Lordship, in their custody. I have also deposited the government fees of 18,050.
So what good will the leave will be now? Since April, the course is going
Lordship,
on.
there is a sub-leave provision. If, Lordship, anyone, Lordship, to 80% attendance is mandatory. If anyone, Lordship, not complete the 80% attendance, there is a provision of sub-leave.
Provision of?
Supplementary, Lordship.
Supplementary.
Yes, Lordship.
Where is the relief in the OA?
Lordship, page number 32. That is relief portion, Lordship. Page 32, relief portion.
Yes, 8%. Page 30.
32, Lordship. In the starting from 31, last paragraph, relief short for. There are the, Lordship, at the top, page 32.
There is no prayer for NOC.
It is, Lordship, Lordship, I am reading, Lordship, setting as in favor of the applicant by allowing him to avail any type of leave credited into his account with immediate effect by issuing necessary release order. That is the, Lordship, without release order. They can, by way of, Lordship, NOC or any release order means, Lordship, NOC to pursue the course.
You have not approached them for any such relief. You have approached them only for leave after obtaining order of this court, and that has been rejected. We are not going to pass an anticipatory order in your favor. That also when it is pending before the tribunal.
Lordship, there is no bench available at this stage.
So
Lordship.
what can we do?
That is
You have
your
done nothing. You are not interested. You should have asked them to give you NOC. You could have gone after without taking leave, without taking any salary. You are relying upon a judgment where he has taken leave without salary. Who is stopping you?
Lordship, on any condition, Lordship, I can, Lordship, kindly, Lordship.
Then go and ask them with any condition.
Lordship, this is a common format for application.
Go and ask them on any condition. Who is stopping you, sir? Why are you telling us we are not the leave sanctioning authority?
No, it is true. But Lordship,
You have to go to the authority.
direct the concerned authority to allow me.
Yes. So you want anticipatory order. That is what we are saying. We are not going to pass any.
Lordship, I am, Lordship, kindly see page 63. This is the common format
You
for
go and
application.
apply. Go and
Yes,
apply.
Lordship, I have already applied. Lordship, 27. Lordship, page number 60. This is the common format. I have already applied. That has been forwarded by the Lordship Principal Sagardatta Medical College. I have applied on 19/3/25. This is the common format for any kind of application, any kind of leave, Lordship. And page Lordship 61 and 62, Lordship, I am submitted the Lordship government fees, and 62 my admission, Lordship. All document has been Lordship kept in there.
You have not applied for any kind of leave.
Yes, Lordship, I have applied any kind.
No, you have not.
No, Lordship, page 81, Lordship, kindly see. Page 81.
No, you are showing us from the format you have submitted at page 63.
Yes, Lordship, it is initially, Lordship, first round of litigation. This
Which kind of leave you have applied for?
Lordship, here, Lordship, page 63. Lordship, it is common format. Here, Lordship, any reserve.
Look at the top of the
Yes,
page,
top.
sir.
Lordship,
You have
prescribed format.
you have put a tick mark on trainee reserve.
Trainee reserve, Lordship, I have
That
not,
is your application.
Lordship, trainee reserve, I am not entitled because I have already crossed the page.
You have ticked it.
Lordship, there is no another format. That it is format. Thereafter, Lordship, in hard copy format, Lordship, I have submitted, Lordship, as per in terms of your Lordship, page 81. Lordship, paying for 1 year any kind of leave. Page 81,
This
Lordship,
is
kindly
not a
see.
format. This is not a format.
Lordship, it is in terms of your Lordship's order. I am quoting your Lordship's order in reference of WPST 140. Praying for 1 year any kind of leave, such as EL, UOL, half pay leave, commuted leave, etc.
You have omitted leave without pay.
Lordship, maybe, Lordship, if
You have omitted leave without pay. Where is the leave without pay? So
Lordship, extraordinary leave also written here, Lordship.
that is without pay.
Extraordinary pay, Lordship, without pay, Lordship.
Extraordinary leave
But
is without
Lordship,
pay.
already,
Which rule says without pay?
already, Lordship,
So you are avoiding to show any rule. You are just continuously making submissions. Whatever you are being told, you are saying.
Lordship, your Lordship asked me, Lordship, for study leave. That is, Lordship, general rules. This is the general rules, Lordship. General order, Lordship. Kindly see.
They have already rejected. Where is the right? You want to go for leave without pay, you apply. Who is stopping you?
Lordship, this is second and kindly appreciate, Lordship, course already started.
Sorry.
Second round litigation, Lordship. I am.
If you are not interested in pursuing the course, don't do it. What can be done?
They should.
If you are interested, you would have gone without pay like that person has gone, whose judgment you are relying upon. He was interested. He told the court that I don't want anything. I want to go for study. Court said, all right, you go without pay. You are saying, I will go, I want to go, but I must get salary also.
I am, Lordship, already rendering service more than 20 years. There's sufficient leave in my credit.
Keep making
If
that
there will be
submission.
allow, Lordship, earn leave or any kind of leave.
Keep making that submission.
Lordship, I have already
That means
elaborated.
we will ultimately be of the opinion that you are not interested in your study.
Lordship, I have continuously, Lordship, touch with them.
You
Lordship,
cannot
but
have the best of both worlds. You cannot get your salary and study everything, and public is not being served. You are being paid salary.
I can say
You are
that,
a doctor.
Lordship, yes, Lordship. There is another doctor also there. He is also radiologist.
Very good. Very good.
And Lordship, I have to perform duty anywhere where I have been placed.
Yes.
Lordship, and it is within, Lordship, Kolkata, within not that
All right,
far
that's all.
distance. Lordship, kindly, Lordship, accommodate any kind of leave or
We have understood what you are saying.
Lordship, I want to pursue the court, Lordship,
No, you
because,
don't.
Lordship, it is
You are
lucrative
not
offer, Lordship,
interested.
at this,
You are not interested.
at the age of
You are more interested in leave than your course. Since April till September, you have not attended
Then,
the
Lordship,
course.
no,
You
Lordship.
are just
Lordship,
pursuing this
how
battle
it is not possible
because
until,
you will not go unless you get a salary
until
for
and
the leave.
unless, Lordship, the principal Sagardatta Medical College not releasing me in any of the mode.
They will not, because you are not ready to go without pay. How can they release you? Unless you are ready to go without pay, how they can release you? They will not release you.
Lordship, in that case, Lordship, kindly fix the matter. Lordship, tomorrow, Lordship, I shall come with the instruction from the.
We are telling you since such a long time, he has relied on a judgment of a colleague who has gone without pay and he wants to go with pay. How it can be? Matter is adjourned for the day so as to enable the Don't call the hearing matters. Don't call the hearing.
Wait, my lord. Obliged.
Obliged.